talk amongst ourselves at the intermission? Hello? Excuse me. Thank you. Cinco de Mayo. Oh, Vince, there's a you want to put that PowerPoint on?
Yes.
Okay, very good. All right, thank you very much. Thank you for the meeting of Cinco de Mayo Planning Commission. We'll start with roll call.
Chair Pevsner.
Yes, please, yes.
Vice Chair Dennison.
Here.
Commissioners Dallas,
Here.
Hutt,
Here.
and Spears.
Present.
Okay. So, before we go into the approval of the agenda, I want to bring up an item that we discussed. Quiet, please. Try and talk as loud as I can. We're going to bring up an item that we were discussing offline, but it's regarding the closure of public comment, and I agreed to take a poll amongst the commissioners of whether we would reopen public comment, because we did close it at the last meeting for a number of reasons, one of which there was someone who represents Protect Sierra Madre to give a long I don't know, what do I call it, rebuttal or just response to a letter from the applicant's attorney, and didn't feel like they got a chance to present that. So I'm going to, before we go on to the approval of the agenda, I'm going to modify it and take a poll amongst, or have a slight discussion, an open session with the other commissioners about reopening public comment from the last meeting. Any, just to get a consensus. It's really my decision, but I really want to know what everybody thinks, and I don't know.
I would like to reopen public comment at each one of these sessions. I think that we learn more information at every one of these sessions, and we should solicit that feedback from the public.
Okay.
Yeah, I concur. I think everybody should have plenty of opportunity to talk, and especially as we go through. I mean, we haven't had much yet that's changed, but as we go through this and see different parts or people suggest different things, I think it's important to get the public's feedback on that. So, yeah, I'm in favor of hearing the public.
Peggy? Just.
I don't know. We're here to listen to the public, which we've done at many meetings, and then there's also the rules that govern these meetings. And it seems to me that we have had plenty of opportunity for public comment, and the reason to open it up again doesn't seem justified by any new material being presented. So I guess I would say let's just keep moving forward.
Okay. All right. I mean, sorry, we can't hear. She basically was not in favor of it. She feels that we have had enough information and input.
And there's no new information being proposed to be presented.
Yeah, one of the contentions is that their attorney, please, we're still discussing this. I'm just saying.
That's not my understanding of what I read.
That's fine. Bob?
We're here to gather information and to make an informed decision, and I think our informed decision should be based on everything that we get from the public, and if there are pieces of information that we can use to be better informed, then I think we should be patient and respect and listen to it. What I am not in favor of is personal attacks, and at the last meeting we had members of the audience who implicated a member of the city council, who made disparaging remarks about the city clerk, and those kinds of things. This is not the body for that. If you have those kinds of concerns, you can take it somewhere else, but we're not a regulatory agency in that regard. So I would like to hear facts, and I would like to hear the things that are relevant to the project, and I think that will be, that's what I plan on using on making a decision.
Okay. All right. Well, I appreciate that, Peggy. I mean, it's ultimately my decision. we've discussed it. I've had quite a back and forth. One of the representatives from Protect Sierra Madre and I said I would take a consensus, and if the consensus was that we could open the public comment, I would do so. So, having said that, that speaks to our agenda. I just want to make sure that people understand what's going to happen if I open the public comment on the action item, that when we go to the community input section, that's for things not on the agenda. So therefore, anything you talk about that's concerning the Meadows project will be not on the agenda. So if you came here thinking you were going to speak on that because we weren't going to open the public comment, please shift gears. I would appreciate that. And we will, I also agreed that if the consensus was that we would open public comment, that there was an attorney who here for the Protect Sierra Madre who wanted to speak and get an extended time. Apparently she's not here, the representative's not here, but there's someone here to speak for her, so I may allot them a few more minutes of time so that they can try and say what maybe she was supposed to be saying at that time, and we'll just play that by ear, and then I'll leave it open-ended after that for anybody else to speak, but they'll be the first speaker, and that includes the applicant and anybody else, okay? Understood? Good. All right, very good. So then I guess that changes the agenda a little bit, other than we're going to have open public comment, so that moves to the approval of the agenda.
I move that we approve the agenda with the edited addition of public comment in regards to tonight's subject matter.
Okay.
Second.
All right, second, and those in favor?
Aye.
Okay, very good, passes. Now we go to the approval of minutes of the last meeting. Anybody have any changes, additions?
I didn't have any changes.
Okay.
Move we accept as presented?
I'll second.
Okay, so seconded, so moved. All those in favor?
Aye.
Passes unanimously, great. Our council liaison, I believe, is not here. If there's anybody acting on her behalf. Okay, we're good. We'll move on to the community input. That's for anything that is not on this agenda. If you came to speak on something other than what we just discussed, you may come up at this time, and we'll give you 3 minutes.
Good evening, commissioner members. My name is Natalia Flores, and I am with the Sierra Madre Fire Department. I wanted to share with everyone in attendance some information on a couple of important upcoming events that the fire department has planned. On Saturday, May 21st, the fire department, in collaboration with our Public Works Department, will be providing free curbside vegetation hauling and chipping services. This event will allow residents to get rid of any hazardous vegetation on their property and place it curbside, where our fire department and our public works crew will pick it up, haul it to our city yards, where we will chip it and recycle it. These services are free of charge, and these chippings will also be used for future giveaways and mulch giveaways. We are encouraging all of our residents, especially all of our residents who live above Grandview, to please register for this event and take advantage of these free services. Registration is now open for our May 21st event, and you can register by visiting smfdchipperday.eventbrite.com. There are also flyers in the back of the room with all of the information, as well as with the 2022 event schedule, so that you may also participate in some of our other great community events that are coming up this year. This event is part of our Fire Hazard and Fuel Reduction Program, and it was made possible through a grant that was awarded by the California Department of Forestry and Fire Prevention Program as part of the California Climate Investments Program. So thank you very much for having me. That's all I wanted to say.
Thank you.
Deb Sheridan, Valley Vista Drive. Good evening, Commissioners. Thank you very much for reopening the comments once you are done with your deliberations, or however you decide to do it. It has been very confusing for the public whether we should be allowed to speak or not allowed to speak, but I do thank you. I do have one question, though. Because you were not going to allow this originally, I'm wondering if this is a continuation of the April 7th meeting, because as some of us know, it did end at 11:30. So I don't know if you can answer that, but it seems to me that it should just be more of the same meeting rather than count as a new meeting. And I thank you, as always, for doing your very difficult job.
Okay. Thank you. All right. Oh.
First, I want to congratulate Mr. Spears and his wife for 2021 Citizen of the Year. You really have worked hard to make Sierra Madre better, and we do all appreciate your work. I've seen you out there doing things, so thank you. Susan Newhausen, top of Grove Street. So I actually also want to address, so this is process, the decision to close further comments. And so I guess part of the question is this going to be every time that you're going to be deciding whether there's new information, or is this now going to be something? Because it wasn't clear to me that when you said comments were closed, I thought it meant for that particular meeting. It wasn't mentioned in the minutes, so we really didn't have an idea for it. And then when Mr. Gonzalez was told that several residents, wanted to speak, he was saying, no, it was closed. And that was very confusing to me, because if you look at the first line of all the agendas, including today's, it states the Brown Act provides the public with an opportunity to make public comments at any public meeting. So to me, it was restricting public comment on this critical project when the Planning Commission has already said there are so many issues with the project. I found a bit outrageous. Until now, you've always been receptive to hearing from the public on any subject, and we really have appreciated that you listen to the concerns of the citizens of Sierra Madre. And it feels to us that there's undue pressure on the Planning Commission to move quickly to approve this project, even though it doesn't adhere to the general plan. So, Ms. Dallas, you made the comment that there's been no new information, but actually the city staff added new information in response to your queries last week, and actually there are some comments about that I don't think all of them are completely accurate, or they're still missing information. And it also appeared based on Mr. Pevsner's letter in response to an email of Mr. Baccio on May 1st, where he said, and I quote, "The Commission is still trying to process all the information we've received." So to me, that suggests that the written public comments have not been read. There hasn't been time and considered by the Planning Commission, in which case that's why it is important to hear it in public, because you may not have time to read it. And the other comment was, I'm not sure having Ms. Grossman-Palmer reiterate her letter would be beneficial at this time. And so you'll hear later then, now that you said it could be done, about it. But I think a concern, it would be nice if we could get her on the agenda next time, because clearly, not knowing if she could speak, she wasn't going to drive all the way here. And there are big issues that are coming. And then I just want to quote one thing. So back in 2014, regarding 1 Carter Stonegate, John Holt wrote to the General Council, to the City Council. He was a member of the General Plan Update Committee then, requesting that each member act reasonably, vote for what you believe is in the best interest of the town, and ignore the legal threats swirling about the project. He added, quote, "I believe that the legal consequences feared by some are vastly overblown, and that the approval or denial of the project is well within your legal discretion, provided that you ground your decision in the requirements of the General Plan, Hillside Management Zone Ordinance, and Settlement Agreement." And later on he wrote, "Hold firm to the General Plan and Hillside Management Zone, require strict compliance even in the face of saber-rattling attorneys." So I would just ask that you please keep his 2014 comments in mind for this proposed new Urban West project, which doesn't meet the requirements of the general plan, which is why the developer and the Passionists in Illinois are asking for a specific plan that makes a mockery of city requirements in the general plan.
Yeah, please.
So as
That's- this
citizens
is-
of
you can
Sierra
s-
Madre, it's our duty to comment. I'm done. Thank
You
you.
can put this
I have
on.
a question.
well, go ahead,
What
Peggy.
is the new evidence or the new information?
Well, I guess for one, I don't really know what you mean by evidence. I don't know that this is a.
I meant information, new information that would affect the decision going forward. What is the new information that's been
So the,
discovered?
There's
since
going to be a
last meeting?
there's going to be a presentation about that. That's what I was going to get.
I mean, the
at.
city, the
'Cause I
city
was-
staff responded to your queries, and some of the information isn't complete or is, to me, seems a little inaccurate, so I thought it was important that we should be able to comment on that as well. And the other thing is, think about it, this is a really complex issue, and we only have 3 minutes to speak. And so, there are a lot of things we all want to bring up, and not disparaging people, but just what we consider facts that we appreciate your consideration of. And so 3 minutes is really not much time to get that out. It's just doing it a one-time thing. So thank you.
Okay. Yeah, I'll just say that that's my decision, Peggy. Between a back and forth, there's things that you saw, some of the information that came back and forth. I decided that, since some of the stuff I wasn't fully aware of, it was worth taking a consensus, and I was willing to reopen the public comment section, and it seemed relevant enough because I think you got emailed the thing. I don't know if you read all 174 pages of it, but
Read the summaries.
yeah, so that's the kind of thing. So I didn't want to because I thought, as far as I was concerned, we had closed the public comment. That was the procedural issue. But under the circumstances, since it's my decision, I decided after the consensus we would reopen it. But I appreciate your input and comments, because going forward, what we don't want is another cavalcade of redundancies with words that sort of repeat the same thing, and then everybody taking every word down that everybody says. This is not a court of law. We're a judicial body, but we're a quasi-judicial body. So we don't really have that kind of authority, and we're not here to debate, the applicant's application to us versus the people, or protect Sierra Madre. It's not a court of law where everybody gets to tell their side. It's more or less gathering information, and that we have to make a judgment on the application that's been set before us. And that's all we have. We don't have any other application. We don't have any other project that they want to consider, and that's our job at this point, and that's why we're trying. I just thought when I first got the request that I wanted to just move forward with the deliberations because we haven't been able to do anything. So, but in light of what's going on, I don't have any problem with letting Ms. Grossman-Palmer have her say, or her representative, to put more information into the context. But it's not us versus them. It's we have a project to evaluate. That's our job as the Planning Commission, and that's really the only job, and not to take testimony, let's say, from everybody here. Your input is your input, but it's not a testimony, because nobody's held, sworn in. Nobody's going to get held for perjury if they tell a lie or half-truths, because frankly, I think I've heard quite a few. But so, having said that, I mean, we did close the public meeting after back and forth with Mr. Basio, who I assume is going to come speak for Ms. Grossman-Palmer in a minute. I decided it was, in our best interest to do so. I didn't want to try and guarantee that I was going to open it because I didn't have a consensus from everybody, and I couldn't ask everybody privately. So, and either way, be that as may, we'll move on to the action item of the Meadows project, and I guess
We still have several people who filled out.
for not on the.
To speak not on the agenda.
Oh, I'm sorry. Is there anybody else that wants to speak on not on the agenda? Community input. This is the community input section. Before I close it, this is not on the agenda, and since the Meadows is on the agenda.
Alex Arietta at Edgeview. I want to talk about the water situation, and in terms of what was communicated just a few weeks ago around the Metropolitan Water District that supplies the San Gabriel Valley Municipal District with water, and announcing the significant restrictions that are going to go into effect and are in effect now. And I'm very concerned about it because what the current state of the water situation is today is 10 times worse than what it was here in this city when the last water moratorium was implemented. And I'm concerned that prudent action is not being taken to seriously consider what the ramifications are if nothing is done around this. And when we talk about the 42 homes that are being developed and net water zero impact, it just doesn't add up at all. And so I really want to encourage the Planning Commission. I had the same discussion with the City Council to take another hard look at this and to seriously consider it. The second thing I wanted to talk about was in terms of the significant amount of letters coming out from the developer, New Urban West. One,
Is this on the
Two.
project itself? Is this on the project? You
3,
wanna-
4, 5. Well, it's pertinent to it, but it's not directly spot on in terms of any of the agenda items for tonight. So it's not directly on the agenda. But the point I wanted to make
Go ahead.
is there is a lot going on, a lot of marketing, a lot of efforts to try to push influence across this city, which I think talking with a lot of neighbors, a lot of residents, it's not welcome, it's not appreciated, and I think it's not organic. I mean, this most recent Neighbors for Fairness, everything is funded by New Urban West. And I just find that to be incredibly not right on 10 different levels. And I think that it's just a very blatant attempt to secure influence for this project getting through as quickly as possible. And I simply think it's unacceptable, it's not warranted, and it's inappropriate. And I really wanted to bring that to your attention. I brought it to the City Council's attention, and I hope that you take that into consideration as you're looking at things like the EIR and other key things we're going to be talking about, because it's been very much the approach that they have been taking so far to ram this thing through. Thank you.
Okay. How many more? How many, Jen?
Hi, good evening. Peggy, I've never met you. Thomas, I've never met you. William, John, a familiar face, and Bob. My name is Patricia Barron. I live at 160 West Carter in Sierra Madre. My husband and I have lived in Sierra Madre for over 45 years. I spoke to Father tonight because I was so upset at the flyers that were left on the door that intimated that the people of Sierra Madre are against the monastery. And this really struck me as so ingenuous and upsetting. I grew up taking my kids to the fiesta on the monastery grounds. My father took me up there because he did the draperies at the monastery. Used to be able to go up to the Stations of the Cross. Beautiful, quiet, lovely. I just feel like people need to start telling the truth. And as a longtime resident, I was so insulted and taken back. Not only did we get one flyer, we got the same flyer on our door the next day. So I appreciate, really I do, all the hard work you do. It's an incredible amount. And I know you have the city's best interests in mind. And I just want to restate that citizens of Sierra Madre are not against the monastery. Thank you so much.
Thank you. Thank you. Not, this,
You let me know when?
yeah, this is still community input. I'm sorry. Thank you, Gary. Who else? Anybody else not on the agenda?
Yeah, I turned in my car.
Okay, that's fine. Just want to make sure since we started this out differently.
I'll be very brief and to the point.
Sure.
I'm Nancy Beckham. I live at 337 North Lima. And I can't thank you enough for allowing Gary Baccio to speak to you tonight, because I have to tell you something that doesn't sound right or feel right to me. There are 3 rows sitting right here of all the minions that have to do with Jonathan Frankel and this project.
Okay,
Fine.
please
But
address us.
you wouldn't let us have our attorney come.
No, I didn't say
I
that.
appreciate the fact that you're letting John or Gary speak for her, but there's something wrong with this picture, and that's all I have to say.
Okay. I expected her to be here. I left
Well,
it
but
very
you
open
didn't
for
get
her.
back to us in time.
Yeah, well, I'll let Gary address that. I think he knows that we did.
This is not on the agenda. This is just to elaborate a little bit about Patricia Barron's statement, because we're next door neighbors. On the Scott Oliver, 144 West Carter Avenue. I have Ring camera, as many of us do, and I have my phone next to my bed, and that's the way I know if there's an intruder on my property. And at 5:45 a.m. on Friday morning, my Ring notified me or binged that I had an intruder on my front porch. And I got up and ran, and I saw a gentleman leaving my property. He apparently had hung at 5:45 in the morning on my door the propaganda, which I saw, and ridiculous. But anyway, I called the PD and I said, hey, what's going on? Basically, I was just traveling under the delusion that you couldn't perform any commercial work in town before 7 a.m. I only know that because when I built my house, we couldn't use a power tool till 7 a.m. So I thought 7 a.m., you know, the time of 10 p.m. to 7 a.m. is peace. That's the peace time. So I just couldn't understand why there was a commercial venture going on at 5:45 a.m. to put propaganda on my front door. This man touched my front door. How many people ever gone to bed and forgot to lock your door? Anyway, Saturday morning,
Me.
oddly enough, 5:45 a.m., my Ring goes off again. I run to the window, same guy, walking off my property. I get on the phone to the PD. Oh, by the way, on the Friday, the PD said they'd send someone out. I gave him a description. Only guy on the street. Saturday, I call up, gentleman dispatcher. First one was a young lady. This was a gentleman dispatcher, and he said, well, who are they? And I said, well, they left propaganda from the monastery. He said, hold on. He said, they paid for a permit, sir. They're entitled to solicit your home. I said, at 5:45 a.m., people are allowed legally to walk onto my property and touch my front door? This is coming from my police department? Yes, sir, that is correct. And stop yelling at me or I'll hang up. This phone's taped, okay? I was so livid, and I brought up the 7 a.m., and he says, no, that's construction, sir. That's entirely different. So that's our, oh, and he said, if you don't like it, you can build a wall in front of your house and move your mailbox to the street. Thank you, Sierra Madre PD. Thank you. I'm just amazed. Anyway, so I think you should consider everything when you vote.
Is there another one, Jen? You want to just call?
Seems like everyone filled out too.
Oh, okay. Well, if that means, I'm just going to state we're going to close this community input unless somebody jumps up to talk on something that's not on the input on the agenda, and then we'll move to the public hearing item, action item. Let's go ahead. We have a presentation, right?
We do have a PowerPoint presentation.
Okay.
And as I go through this presentation, please feel free to ask staff, the city attorney, or the applicant questions as we go through each of the action items that were identified by the Planning Commission at our June 7th public hearing. And this is a continued meeting from the April 7th, 2022 meeting of the Planning Commission. The Planning Commission will continue their deliberations regarding Phase 1 proceedings, which include certification of the final EIR and mitigation monitoring and reporting program, adoption of a specific plan, general plan and zoning code amendments, including the land use map and zoning map amendments, approval of a lot line adjustment, and entering into a development agreement. From the April 7th meeting, the Planning Commission identified 15 action items. I'm going through each of these items one at a time. Action item number 1 was to organize a site tour. That has been completed. We actually had 3 site tours on 3 different days that included both City Council and Planning Commission. It was limited to 2 members of the Planning Commission and City Council at a time in order to prevent Brown Act violations.
I want to state for the record that the tour was very informative. And we see maps, but walking the site was very, very helpful.
Yeah, so are we just questioning now if we want, or are we deliberating, or
No, no,
You
we
can
can
do both. We
We're gonna
are
let the public talk.
deliberating.
Yeah, you can talk, I think openly, we can re-ask questions, but I'm gonna let the public talk. But as we go through this, if you have some things, I would say, rather than act as if this is our deliberation time, just bring up what you want. If it comes up again in deliberations, that's fine.
Okay.
But I think we've had so many times we haven't been able to ask questions, we've been sitting here almost mute.
Right.
So feel free.
I just want to say that this is somewhat redundant, or it's entirely redundant to what Bob said, but it's really important. It was really helpful to see the site. It's really useful, and I think one of the issues that we need to do, and the city attorney has drilled into us, is that we need to make clear what evidence we're making our determinations on, and we have lots that are in the record, but I think the site tour is an important part, for me, an important additional information that we gained. So I just wanted to make that really clear.
Yeah, I agree. The site tour really did a fantastic job of putting into proportion the size and shape of the park, the location, the lay of the land, the elevations, the buffer zones. Seeing it on paper, we're pretty good at doing that.
Mm-hmm.
We do a lot of that, but walking a 3-acre park is very different than looking at it on a plan.
We've heard a lot of, the concept of proximity has been raised by a lot of people, and you know, on paper, you don't get the sense of what that is, and you know, what buffer zones do and things like that, and so that was very, very helpful.
Yeah, I think the other thing is all of the papers we have are flat. And so a diagram on a flat piece of paper is very different than looking at it at elevation.
Okay. Peggy, did you go? Go ahead.
The tour was very informative, both about the retreat center property and the properties to the south, especially the Bailey Canyon Park, and then a little bit of the western side. It was all very informative. The like 6-foot drop on the south side of the property line was something that didn't jump off the plans in 2D. You know, kids falling into swimming pools would not be good. And so, so it's things like that, and we got to talk to the neighbor that was at the top of Crestbell, and the staked property line pretty much follows the retaining wall, but it does veer out just a little bit at her property, so there's an argument there that she was right about that. So it was interesting.
Go ahead.
And I'd just like to comment regarding the site tours that the Planning Commission and City Council spent really on average upwards of 2 hours for each tour. The second action item was requested by the Planning Commission was to outline the procedure of the entitlement process. So the Planning Commission will consider adoption of the entitlements by resolution, and they're grouped into 2 separate resolutions. One is for the EIR certification and mitigation measures, and the second is the consolidation of all the items that you see, including items B through F. So it's all of the additional entitlements. But the Planning Commission also wanted to know how should they approach reviewing these procedures or the proceedings. And really what we're here to do is, even though there's 2 separate actions, both for the EIR and the specific plan, they should be approached collectively. And the specific plan essentially outlines the project scope, and the EIR analyzes the environmental impact. So we really can't separate those 2 documents. So we will consider those collectively and then move on to the rest of the actions again, under one resolution number, but the general plan amendment and the zoning code amendments could be another collective action. And then moving on to the lot line adjustment and the development agreement. I'd just like to point out that the lot line adjustment is actually a ministerial action, so it could have been approved by staff when we received that application. There is a provision in Chapter 17.60 of the zoning code that if you have numerous applications, even ministerial actions, those could be moved forward to the Planning Commission since they're considering other items as well. If you have any questions?
Yeah, I mean, we talked about the resolutions on these and, you know, taking them together when we adopt the formal resolution. But I think we also talked about, and I'd like to discuss our sort of informal review of the different parts, because I think we do need to look at the whole thing, and when we reach the end, we need to be voting, I think, on all of them together, right? Because, as you said, you can't separate out the CEQA document from the entitlements, and all of the entitlements work together. Just like the lot line adjustment is really, the whole point of that is to allow the general plan amendment and the zoning change, because you're setting the parcels up for those changes, right? But I think for our informal discussion, as we deliberate, I think, to me, it makes sense for me, I sort of think of the CEQA at the end, but if we want to do it at the beginning and the end to sort of get both brackets of the thing, but then I think we should talk about the general plan amendment first. Because if we have a consensus that it doesn't make sense to do the general plan amendment, we shouldn't wade into the specific plan because we're wasting everyone's time, right? So it makes sense to me to get consensus on the general plan amendment and then go to the specific plan. I think the lot line adjustment is sort of just goes along with those, and then we can, you know, take on the development agreement, and then wrap up, circling back to the CEQA document. And I think one thing I'd like to say about some of the comments we heard earlier, about that we have a lot of things to go through and process. One of the important things you need to understand about what that means for us to process stuff is to talk about it in open public hearing. Because it's not that we haven't read it yet. I have thousands of pages. It's that I want to share my views with the fellow commissioners, and I want to hear what they have to say. And I don't know if they're in favor of it or against it or sort of in between, or what parts they think are really important. And so in order for us to go through all these things, it's really important for us to discuss them and deliberate and get some sort of working consensus. And so if people have new information and they want to comment on, well, you guys are coalescing around this, but you should do that because of X, Y, and Z, that's great. That's really helpful information. But if we never get a chance to sort of discuss and collaborate to coalesce around a consensus, and then we just keep hearing more testimony, that's really hard, because it's hard to process where that fits in. And so I really think that I totally want to hear everything from the public. I don't want to muzzle anybody, but we also need to hear from the other commissioners to figure out sort of where we stand and how our thoughts get put in. So I think that's, for me, that's really important.
That's kind of my thinking. That's where I was coming from.
Okay, proceed. I'm sorry, go ahead.
So, action item number 3 was to provide clarity regarding how design review of the specific plan will be conducted. And essentially, design review will occur in phase 2 proceedings. And at that point, the commission will evaluate the plans and elevations in totality. It won't be on an individual lot basis like we did for 1 Carter. So the Planning Commission will also not be able to apply the subjective design review findings that we have in Chapter 17.60 under the design review permit. We would then rely on the design review outlined through the specific plan. And specifically Chapter 3, the development plan and standards, and Chapter 5, design standards and guidelines, and really in totality the entirety of the specific plan. So design review will include evaluation of 4 architectural styles, There are three variations in elevation for each of the architectural styles. It would also provide 4 color schemes, and overall it would result in a total of 12 different building elevations and 16 color variations. And I have one more slide on this topic. So the specific plan in section 3.5, the landscape plan, that focuses primarily on a drought-tolerant tree and plant palette. It also addresses the conceptual parks and recreation plan, wall and fence plan, retaining walls, etc., and the type of materials they would be constructed of. Site planning and design in section 5.4 of the specific plan addresses development standards, including requirements for building height, setback, grading, building placement, and orientation. And architectural design in section 5.5 would address building massing, form, scale, articulation, roofing materials, and supporting design elements such as windows, doors, exterior materials, and color. Any comments on action item number 3?
So I just want to get some clarification. So it sounds like what you're saying is that when we review all of the 12 building elevations in phase 2, the only standard we have to go against is the specific plan?
The specific plan essentially replaces the zoning code specific to R1 development standards, and yes, essentially what we're doing, the specific plan is as a higher level of specificity than the underlying zoning code.
So that's a document we need to spend a fair amount of time getting comfortable with.
That's very true, yes.
But the only finding that we make is consistency with specific plan, right? We just have one finding?
Yes.
I mean,
Specific to, yes, the resolution.
my big concern, and I thank the staff for elaborating on the process and discussing how it's currently set up to work. Currently set up to work, not how I'm in favor of. I have great fear that the phase 2 design review is nothing more than a rubber stamp. And I think that during this process, we've heard a lot of concepts that, don't worry, this will be taken care of in design review, we'll address that in design review. I don't see that a one finding that's general consistency with a specific plan that is really sort of high level is going to get us any ability to craft or tailor anything. And at one point I specifically asked about this, the ability to impose subjective design review, our current standards, using the development agreement, and that I think is something that the developer can voluntarily agree to. That was my understanding. We can have the city attorney weigh in on that. But if all we're doing is looking at a few elevations, I don't see why we don't put those in the specific plan and approve them now, if everyone's good with that. Because one of the things that we've heard is, look, we can't do this phase 2 design review because it's going to involve all this stuff and there's all this detail. But if we're talking about 4 plan elevations, that's not all that much. We could stick it in now and review it, and then everyone would know what we're getting up front. I just feel like we're doing the shell game, where we say, don't worry, we'll fix that on design review, and then when we get design review, we're going to say, well, you only get one finding, and it's really wishy-washy, so you pretty much have to approve it.
I think it's fair that the developer has a specific plan, so he knows what his rules are, just like we in the town know what ours are on our property with the city codes. But the specific plan, in order to be effective as a total design review of the property, needs a lot more fleshing out. It also needs a lot more consistency with the rules everybody else plays with in town. There's just for instance, the way they calculate height, it's to the finished floor, the existing grade or whatever, whichever is higher. But in town, it's all these different levels, whichever is the lowest, which really makes a difference.
Especially
And
when,
so-
especially when you have elevation change.
And
right?
things are going on with the lot area the same way. They're taking the HOA space, counting that as lot area, and then putting a house on it, but only a smaller portion of it, and they get to go 50% of that, of the bigger area on that smaller pad. These places could potentially be massive, and the lot sizes vary dramatically. And if we're using one size, 4,000 something for each property, we could potentially have really chunky houses right next to each other. But then on that huge property at the bottom, tons of space. So it really needs a lot more fleshing out. That's why I liked your idea of let's do the general plan
amendment.
concept first. Let's make sure the big idea is working first before we spend a whole lot of time with this.
Yeah, when we do design reviews, sometimes we look at the relationship between the structure and the neighboring structures, and I don't think that's in our purview. And so, do we get to ask rules like, okay, does somebody's window look into somebody else's window, or are they going to make sure that doesn't happen, or what are the other things? So, I agree with John. It seems like just to say, yeah, we agree, there's a lot of unknowns and a lot of things that are kind of whatabouts that I'm not quite ready to agree to, although some of the architectural styles in general are not offensive, but it's a lot of times it's the relationship between one structure and another and another and another, and then what is it? It's totality. Yeah, I agree.
Well, you have to figure that they want to sell these properties, so they're not going to build windows looking into each other. But if you say that, you could only put this much mass on these two little smaller lots next to each other, that tones it down a bit. And you might want to control, the frequency of the different styles throughout the property or something.
Right.
There are all sorts of controls that would make us feel a lot better about just a rubber stamp design review.
Yeah, I agree.
Individually. So.
Action item number 4 was to provide a summary table that compared both the R1 development standards and the specific plan development standards. And Commissioner Dallas was alluding to some of the deviations that the specific plan does. In this case, we're seeing here, and I have several slides on this so we can be able to view the table more easily. As you can see, the minimum lot area in the R1 zone is 7,500 square feet compared to the Meadows. Minimum lot area is 7,800 square feet. Maximum lot coverage, 41% for R1, 50% for the specific plan. And the maximum allowable floor area regarding the R1 zone is actually on a tiered basis dependent upon the size of the lot. So the smallest size lot in the R1 zone would allow a gross floor area of 2,225 square feet. And then if the lot area is greater than that, it's a percentage, 10% over the lot area of 7,500 square feet. And then that multiplier would reveal what that denomination will be. Versus the Meadows project as a one net maximum amount of 4,250 square feet. They will not all be of that size, but that would be the overall net instead of having a.
Can I point out something? That the asterisks on those, the square area, the square foot in the R1 family zone includes covered porches, garages, all kinds of things, accessory structures. The square footage in the specific plan is only enclosed livable spaces, so
And
none of those other things.
It does include front porches as well, though. So
Okay.
you'll see some similarities and then some deviations.
Okay.
Maximum building height, you talked about how height is calculated. They're both 25 feet. The specific plan says from finished grade, the R1 standards will have a perimeter 5 feet around really what would be the pad, or the lowest point of grade on natural grade would be the lowest point that the 25 feet would be measured.
That was from finished floor, the
Mhm.
specific plan, not finished grade.
Or finished floor for the specific plan, finished grade for R1.
Yes.
And then continuing on with this table, for front, side, and rear setbacks, the R1 standard requires a 25-foot front yard setback. And then that also changes if there's a greater setback in terms of the neighborhood average. But here we're looking at 25 feet, and the specific plan is saying 15 feet to the main building, and then 20 feet to the garage. So the garage in all cases would have to be offset by at least 5 feet. The side yard setbacks, again, would be 5 feet, and the same thing is applicable to the specific plan. However, our code does deviate further if the lot is greater than 60 feet. There's a cumulative average that is calculated to determine what the average of the front yard setback would be on that particular block. We also have an encroachment plane, or the rear is 15 in
I'm
both
sorry,
cases.
before we
Yeah.
go on the front setback, when we were on the tour, we were told that the houses to the west of Sunnyside would not have any requests to change from today's code of 25 feet. Is
Yeah,
that,
those are fairly large lots, so they could be treated differently. You know, they're very deep lots, so they could comply with the 25 feet or that average. Angle plane requirements. We have a requirement that has an angle plane. It's a vertical measurement at the property line 10 feet high at a 45-degree angle. Building encroachments shall avoid that angle plane. And the specific plan does not address that issue, so I'm assuming that a two-story building 5 feet from the property line, 10 feet high, will have an encroachment into the angle plane. Therefore, it omits that requirement from the specific plan. And here, as Commissioner Dallas indicated, projections into the front yard. You look across the table, both R1 and specific plan standards. It says non-habitable covered front porch. You're allowed to have in the R1 a 6-foot projection into the front yard setback. The same is true here for the specific plan. Also, open uncovered balconies and open balconies that are covered. 2 different categories there. The first is you're allowed a maximum of 48 inches. On the covered open balcony, it's also a maximum of 48 inches through an administrative design review approval, and that's also true for the specific plan, so they're matching there. Required parking is also complying with the covered parking requirement. The specific plan goes on further to say that the parking spaces have to be within an enclosed parking space per dwelling unit. The R1 could allow for carports. Accessory structures, those are still, such as an accessory dwelling unit, those are per section in the municipal code 17.20.060. they apply equally. And the minimum landscape and front yard, they do deviate 50% in the R1 zone and 40% in the specific plan area.
But in the event that there is a covered front porch that extends 6 feet into the 15-foot front yard setback, we're talking about less than 10 feet for the coverage.
That would be the case, and I think on the elevations, they're going to still hold the 15 feet.
Okay.
This is just the footnotes associated with that table. If I go to the next one, unless you had any questions.
I just want to, before we go past the footnotes, because you know the saw about the devil being in the details, I just want to echo Peggy's comment about the floor area, because we're totally comparing apples to oranges here, and the floor area that's allowed in the specific plan is going to make a lot bigger building than the floor area that's allowed under our code. And so I think that we need to, I mean, my preference would be to just say, I'm going to count the floor area the same way as we do in R1. And then if we're going to let them be bigger, well, let's let them be bigger, but let's know exactly what we're comparing. Because it's hard to make a comparison if you're not using the same scale. That's not to say it doesn't make sense to have somewhat bigger in some places if, you know, for an exception, but I think we need the same measuring stick so we can understand what we're actually granting.
That's right, we need to know when we're making an exception and how much. And right now, we can't tell.
Right, and one other thing is, there was discussion in the staff agenda about the concept that, well, we want to have more floor area because the way the R1 counts it, it sort of penalizes porches and overhangs and things like that, which I actually agree with. But what I'd like to do, if that's what you really want to do, is say, okay, you get X amount of normal floor area, and then you get an extra amount for balconies and patios and porches and things that are exactly those design features, so we don't just get this bigger number that comes back as a giant box with none of that other stuff that's, you know, makes the thing look nicer, and you just exploited it to make a really big one, you know, chunk.
Yeah, this chart is a fantastic starting point. I guess what I was hoping for to be in addition to this chart is kind of, there must be some kind of a design that has been used to determine this number.
Mm-hmm.
There was some logic that this number was determined by, and so understanding what that exemplar would translate to in the underlying code would be super helpful, because I think that that's the challenge that we're missing here.
Yep.
Is that and this goes back to your point about not having the plans for the houses, is that using a different standard than we use today to compare to, and a different standard than once they turn over the keys to the house to the new owner will be applied to. It's kind of hard to understand if this is going to end up being 10 times bigger or smaller than the way that we look at it today. And so that level of clarity, I guess, is what I feel is still lacking.
And it may be helpful for us to, well, I understand that they're going to build tall houses next to each other in close proximity, but just to have the angle plane drawn in on the plan so we can see how close and how much are how the relative closeness or relative proximity that we have in you know, does it go up for, you know, 2 or 3 stories here or what? Because I think with maybe the 1-story buildings, the angle plane may not be an issue, but there may be some others where there are 2-story buildings next to each other that it will appear to be some buildings shoehorned in next to one another. Especially if if we have a concern about height.
The floor plan doesn't really give you a sense of the mass And, you know, the elevations, they're really the elevations they're using, you can see the angle plane. But the code's written the way it is for the single family because it's a graduated thing that goes up with lot size. And that's what controls the mass.
Right.
And so it's, the one size fits all square footage for the houses is not controlling the mass at all. And that's where you have to start, I think. Not just the floor plans or the elevations, just adjust that number to the size of the lots on in the proposed development. So.
Yeah, I agree. And I think we've heard a number of times that, oh, we're not planning the elevations to do this or that, or we're talking about one story here, but I don't see restrictions on that. And, you know, I think this applicant has been very responsive to date, and I've looked on the website and looked at some of their other houses that look very good, but things change over time. And we learned that on One Carter. Sometimes people go bankrupt, and I certainly hope that doesn't happen to you. But we need to have it in the rules. That's what I'm getting at. We can't sort of just do a trust you thing. And I'm very worried that we're pushing too much of the things that are gonna make this project look good to the phase 2.
Right.
When we don't have any guarantee that we're gonna be able to enforce that in phase 2.
I agree.
And this doesn't have to do exactly with this, but I did have a question that kind of overarches all of this is, we've seen the layout, the tentative plan for the tract. Does that get finalized as part of phase 1 or finalized as part of phase 2?
That'll be finalized as part of phase 2. The tentative tract map would be the final delineation of each of the lots.
So then, and this may be a question for Mr. City Attorney, who has not had to participate yet, but we're going to call on him now. In the event, like, would the city council be approving the zoning change of this property and it is forever changed, or is it changed only if houses start to get built? Because I guess what I don't understand is when the tract map gets finalized. Because if it is, my concern being, if it doesn't get finalized until after the conversion to R1, and then development doesn't occur,
Okay. So
it's zoned R1 and hundreds of houses would fit in there under the R1. So if we convert it to R1 and then building doesn't happen.
But we're talking about converting it to R1 with a specific plan overlay. So it would, I mean, they'd have to comply with the specific plan.
But is the specific plan overlay specific to the developer, or does it stay with the land?
It'll stay with the land.
That's what the line, yeah.
So it's gonna, so once we approve the specific plan, that drawing, that layout is what's going to happen up there, whether it's New Urban West or Martians. Okay.
Well, that layout, but keep in mind, the layout that's in the specific plan is sort of an estimate of what's gonna be up there. So the layout that occurs has to be in conformance with the specific plan, but they might tweak that, you know, if you figure out some sewer line is going through someplace and you gotta move one over a little bit or something like that, so it'll look mostly like that, but it's not gonna be exactly.
Right. But if it came back and varied more than a house, we would be able to say.
More than 42.
More than 42. We would be able to say, this is not
What we plan.
conforming to the specific plan.
No,
Vice Chair, if I could answer that question.
Thank you.
I believe Director Gonzalez is going to address that in a later slide. But I'll note that we did look into whether or not we can have a reversionary clause in the general plan and zone change, such that if a condition isn't met that's required to be met, then the zoning would revert back to institutional. And based on our research, it was determined that that's not possible. It's not legal. State law requires us to go through the hearing procedures before making a zone change in a general plan amendment. So what could happen is not meeting a condition can trigger a rehearing such that the city council and the planning commission would consider changing back the zone, but we couldn't have something that would automatically change it back to institutional.
Right, and I saw that, and I apologize for jumping ahead, but it seemed germane to understanding this part of it as well. So that was the impetus of my question, because I did see that a conditional change would be prohibited by state law. So that was why I was curious as to if the specific land, or if the specific plan remained with the property, or
Yes,
joined with.
well, so because it's essentially a zoning condition. So it's for that specific area, for that entire 42 acres.
Okay, thank you.
Go ahead.
Moving on to the next action item, which is action item number 5, to change the floor area calculation to match R1's calculation. There's 2 slides to this, and we'll get into more detail on the second slide. But essentially, the Memorandum of Understanding contemplated modifications to the R1 standard for floor area, as well as many other things, which allowed the floor area in excess of standard measurements, including other issues that we've already discussed. Also wanted to point out here, what you're looking at in terms of the site map below is the surrounding area immediately surrounding the retreat center. The gradations that you see in the legend from light blue to dark blue are showing properties from 2,500 to 3,000 square feet in light blue, and then progressing to 3,000 to 4,000 square feet, 4,000 square feet. And the darkest colors, I think there's one property, the closest one is next to the retreat center, is in excess of 5,000 square feet. These do exclude garages. The assessor's record, or county assessor, is only calculating habitable floor area. And when we do our comparison for other projects, we do the comparison excluding the garage. What we also did was identify per lot, so it's showing the lot number, the lot area in square feet, and applying the R1 standards shows the maximum floor area that's permitted. So in the case of the smallest lot, which is 7,800 square feet, you would be able to build a 2,255 square foot structure, and then minus a 400 square foot garage. Same thing, the largest property utilizing R1 standards would be 3,606 square feet, and that would really be applicable to lot number 1, which is the largest lot at 21,311 square feet.
So the specific plan maximum square feet, well, so, sorry, is this,
The specific.
this is floor area?
This is floor area, the specific plan, this is the R1 comparison. If we were taking the square footage of each lot and applying the appropriate thresholds, this is what you would be able to build on each of these lots, whereas the specific plan does not show that gradation, and it shows a net floor area of 4,225 square feet.
So the specific plan, worst case scenario, is every single one of those lots would have 4,250 square feet or living space.
It could be, yes.
But that's
worst case
That's-
scenario.
But that's also under a different measurement.
Yes.
No, that's, this,
These include the garage where the 4,200.
no, I think you said they
Yes.
didn't. They do?
Yeah, these include the garage, and then you would have, for habitable floor area, you'd back out 400 square
So
feet.
if you had, lot 18 there, that's 7,800 square feet, that you could build 2256, you take out 400 for a garage, you're talking 1850.
1,800, yeah.
So,
So we have
so
to,
the amount of the specific plan is more than double.
wow, you could, or you can just add the 400 to their number.
Yeah, either way, yeah.
Okay.
I think that, one, again, I think that if we're going to consider allowing floor area in addition to what we normally would allow, that's a discussion we can have.
Yeah.
But first, we should have the same yardstick. So, to me, it's just fundamental that we measure floor area the same way so we can actually compare. The second thing is, I understand the quote from the MOU, but we've been told up and down the MOU is non-binding, right? We are approving or denying or conditioning an application that has nothing to do with the MOU, right?
That's,
That's correct. The MOU merely regulates the application process, not the actual approval.
Okay, thanks.
Can those two get added to the,
Please,
packet?
please, 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 don't speak out. We'll let you talk later. It's a correction. Go ahead. Go ahead, Vince.
no further questions on action item 5? Okay, moving on. Action item 6 was to update the commission on the discussions with the county road widening. And the applicant thus far has had held 3 meetings with the county. They are looking at submitting a preliminary application for county feedback, and that is in progress. The county will not, however, consider the application until after certification of the EIR. The exhibits that you're looking at here, the site plan, the one on the top left site plan is showing the exit from the project site to the through the Carter roadway. You can also see the county road that is right coming through here and how they join one another. And it's also showing the 6-foot wide sidewalk on that edge. And I'll go into further detail in slides that'll be coming up soon. And the exhibit on the bottom is picking up from Grove Street. So here's Grove, this is where it picks up, and it continues on to Oak Crest Drive. So that's the improvement. The improvement is proposing to have a 25-foot curb-to-curb roadway. There'll be no parking on either side, and it'll have a 6-foot sidewalk on the north side. I believe I have one other, no, I consolidated all exhibits into this one slide, so if you have any
Thank you.
questions.
I think the sidewalk appears in slide 17.
A little bit later, we'll go into
Yeah.
that in more detail.
Okay.
No further questions? Action item number 7 was to provide a map of the retreat center property with clear lot lines, and the applicant has provided this exhibit to staff and for your discussion. As you can see, there is existing open space designations on the areas in green, highlighted in green. This particular parcel is located in Sierra Madre. This one is in the city of Pasadena. And the applicant would work to create a conservation easement on both. The area in yellow identifies the retreat center that would remain as an institutional use. And the lower area is the project site boundary. And if you recall in prior exhibits, I did have the from the lot line adjustment map, the actually articulated survey showing meets and bounds. I did not include it in this exhibit. I wanted to show the entirety of the site. Moving on to action item 8. There was a request to show the individual lot lines in the land use map. There was there was not a lot of clarity whether these were through lots or the lots stopped up on the top of the slope. So was it just the flat pad, graded pad, was at the property line, or did it actually go down to the street, the lower street? And as you can see here, these are street-to-street lots. So the pad extends from, for example, the lot from Street A down to Street B. And on a portion of that slope would be a homeowners association that would be required to maintain that landscape slope, and that there would be a provision to prohibit any structures within that area as well. So that occurs on streets A and B. Street C backs up to the park. And it also has a similar condition with a landscape buffer.
How does that work? In other words, the part that's darker yellow or orange, depending on what you're looking at, is that?
It could be an easement, a landscape easement, like they are going to be doing on the properties on the west side of Sunnyside.
And as an easement, it's prohibited from
Development.
Yes, from placing auxiliary structures within that area.
And the concept is the homeowners association is going to maintain the orange, but the MDRC is going to maintain the light green.
That's part of the homeowners association. That light green area, those are not on the lots, those are landscape buffers that are not included in any of those lots. And those occur, I see, in 4 locations.
And the park is maintained by the?
The park is a maintenance district that would be maintained in perpetuity by the developer or entity maintaining that property.
And the red slash property is maintained by the?
That's also through the association or the maintenance district. That's showing the buffer, a landscape buffer between the monastery property and the development.
So the monastery's not gonna maintain the candy cane?
No,
Right.
no.
And there's also gonna be part on the west?
There'll be a 20-foot buffer on the properties to the, along the west of Sunnyside at the very back of the lots. That landscape easement will also specify that no structures could be built within that 20-foot easement area, landscape easement.
But that won't be maintained by the HOA because those will be separate. I mean, there's be no way to get at them, right?
I'm not sure if we've really delineated how that would occur. I'm sure if that were the case, it would be, have to have a landscaped access to that. So I believe you're correct in saying that that would be part of that property owner's responsibility to maintain that. They just will not be able to put any structure within that 20-foot area. It could only be developed with landscape material.
And who enforces the easement to the HOA? Is that the HOA itself?
The HOA would have a management board managing the
Right, but I
HOA.
mean enforces is with regard to the no structures.
That still would go to the HOA. Certainly, the HOA can notify the city. We would have conditions of approval, and then we go through our normal code enforcement action to correct that.
Okay, because I mean, again, my concern here is HOAs. The city does a really bad job of code enforcement, and that's not specific to the city. All cities do. It's code enforcement is really tough. HOAs do an even worse job. you know, on my street, the covenants say no one can build a second story, and more than half the houses have second stories. Because nobody wants to sue their neighbor, right? It just, that's a hard enforcement thing. So, again, I think that considering that we're already setting up a maintenance district, rather than having those things maintained by an HOA that are right next to parts that are maintained by a maintenance district, it seems to make sense to me to have those all maintained by the maintenance district, and don't allow the people who live there to, you know, to fence them in separately, so that just from, when you look at it, you know, when you're driving on Street C, for instance, you won't see an orange stripe, right? You'll just see landscape slope, and I think that's really the goal.
So the orange stripes are 3 different sizes as you go from A, B to C. And does that help? Can you help me with what that means in terms of elevation? So I'm assuming on the ones on Street C have a very small elevation gain to go up to a flat lot to the street, and then at Street B is a greater elevation, and Street A is a much taller elevation, because I assume that orange is I'm imagining it as a 45-degree cut, you know, that goes from the street up to a lot.
Yeah, I believe that's correct. It appears that the gradient above Street B is steeper than the area above Street C.
So if one of our concerns is the bulk and massing of the houses that will go on that lot, one of the things that we always look at is the relative height between buildings and what that means in terms of, you know, sight lines and things like that.
Mm-hmm.
So it may be helpful at some point in time to have some kind of drawing that delineates that difference between the lots. And perhaps what would a single-story house look like on it, or a 2-story house from the side?
Yeah, we certainly could provide sightline studies. I believe in the specific plan,
There is one.
there are exhibits
Yeah.
that show that relationship. And if we have questions of the applicant, I was encouraging you to ask those as well, if they can provide greater information. Yes, the applicant would like to clarify the maintenance district conversation that we just had.
Good evening, Commissioners. Just as a point of clarification, the note you see on this legend, landscape at Lot A, which is that striped area, I believe Commissioner Hutt called it the candy cane, that will be maintained by Madre Dolorosa. That is not being maintained by the Homeowners Association. It's very important for the operations of the retreat, as you were made aware, that they really control the areas immediately adjacent, especially to their most holy areas, the Stations of the Cross, their gardens, and their amphitheater as well. So the slopes in all cases are the same, meaning they're all a 2-to-1 slope. So there is no different in gradient as you go across the slopes. You will see in the existing specific plan a section that we cut throughout the entire site, which shows you the elevation as you go up gently a 2-to-1 slope. There's a pad. You will then tier up to the next terrace, but again, all of those slopes are 2-to-1.
Okay. But they are longer at the top than they are at the bottom. Okay.
So, Commissioner, the reason it's longer is because those lots along Street A are just larger. So those lots are about 9,000. The way that it works out, those lots left to right, east to west on Street A are about 9,000, 9,300. Drops down to about 8 on Street B, and then 7. So simply those areas are larger because the lot area themselves are larger, not because the slope is changing.
Okay.
Commissioner Spears, on page 49 of the specific plan, there's a contour map, and it shows that there's only like a 10-foot difference in the orange, but there's actually a 35-foot difference between the properties on the south side of Street C and the park.
Okay.
So it's a big drop there.
And you can also see on page 50 some sections through the graded pad, the street, and a portion of the slope as well, as an example. I'll move on to action item 9. The commission did ask for more information regarding connection to parking and access related to Bailey Canyon Park. This land use map, conceptual land use map, identifies 97 total parking spaces provided within the entirety of the project area. 37 of those parking spaces are located east or along Sunnyside Avenue. 19 of those 19 spaces are located along the new Carter Avenue. And then again, there'll be 7 additional parking spaces within the proposed park. Very difficult to see, but there's cross sections of each of those streets.
I've got a question about the parking on streets A, B, and C. Why is it on the sidewalk side instead of across the street where you get more cars and it would be easier to pull in and out of the driveways without having to see around the cars? It's just kind of a logic question.
So you're saying
There might be a good reason, I just don't know what it is at this point.
here on these streets,
Yeah.
on the parallel streets, why isn't there double parking?
No, why isn't
Why
the
isn't the
parking?
parking on the north
Oh,
side
on the
instead of
north
south?
side.
Where you have more cars and
Yeah.
then it's easier to get in and out of the driveways.
Driveways
Yeah.
on the south, yeah. I think that's a really good
Yeah, that's a logical comment, yeah.
I don't know.
And, we could have the applicant explore that concept as well, unless they would like to address it now and as to why it was cited in this fashion.
Yeah, Commissioner, the reason typically is we like to have parking closest to the front door. So you would not require the homeowner to cross the street in order to get to their front door. They're going to have parking, or their guests have parking immediately adjacent or closest to to the entrance to the home.
Any other comments on this image? Moving on to action item. This is also a continuation of action item number 9. This is where we're addressing the two, what we're showing is 2 sidewalk options, 1 and 2. And in this case, option number 1, which is in the lighter yellow configuration, shows the location of the sidewalk adjacent as part of the 24-foot wide roadway, curb, and then the sidewalk on the north side. There's another exhibit that'll also look at some of the trees that are located within this area. The area option 2 in purple would retain these trees. All the deodars are proposed to be retained. In this location, to be able to save the trees, there's 4 cypress trees that would be required to be removed with this configuration. The applicant can go into more detail about that. There's some thought that they would not have to possibly remove some of them, but these are the 2 options. And I do have, I believe, another slide 9. This does show, again, the configuration of the 2 options regarding the sidewalk, but this particular graphic is looking at new direct connections to Bailey Canyon from Carter Avenue. So the grade to the service road, the county service road, it looks like they would be able to come out and provide another access to the Bailey Canyon Trail from the project site. Again, allowing people utilizing the trailhead to be able to park again along the Carter Avenue and some of the other A, B, and C streets if necessary, in addition to providing additional parking at the park site. Again, also providing that connection at this lower point via sidewalk and crosswalk to Bailey Canyon Park.
And that makes Bailey Canyon Park ADA compliant, or
Yep.
ADA accessible.
Yes, and that's one of the reasons for that configuration of option, sidewalk option number 2 is to achieve and comply with ADA access on that path of travel. Any questions on points of connection to the park and the sidewalk options? I believe I have one more image showing the location of the existing trees. The proposal, as this goes through, does eliminate, I believe, these 4 cypress trees. All of the deodars would be retained, even with placement of the sidewalk along the edge of the roadway.
This is all predicated, the county's not going to agree to any of this until we actually approve something of this order, and then they'll,
That's correct.
okay. So does that mean that they could put the kibosh on this for some reason and not give up that territory? They just, what's your feeling or from them? Or do you know what they've said? I don't know what the...
That would be the conversation that the applicant has had in terms of the feasibility of acquiring these properties in the county lands.
Okay.
If the applicant wanted to speak to that.
Yeah, if you, sure.
Certainly. So we have had a number of conversations with the county, and so what we're proposing is the acquisition of approximately 9 feet of right-of-way for public use. So the granting of public right-of-way by County Public Works is a fairly routine matter at the county, and for an item like this does not need to go to the County Board of Supervisors. This can be approved by county staff. And so generally speaking, as a concept, this is something they do frequently, and they did not express any major concerns or constraints to the acquisition right-of-way in this location.
They just didn't want to say anything until they get what...
Correct. Legally, they are not able to approve an acquisition prior to the environmental review being complete. So conceptually, there is a process by which this is handled at the county. It is something they do rather routinely. They didn't express any major concerns, but the process has to be followed.
What is the limit? You said that this wouldn't have to go to the Board of Supervisors. Is there like some, what is the threshold that, because we had also talked about, going up Carter and the parallel, and also, I mean, there's 2 things. One is that intersection right there at the corner is sort of difficult with those double gates. And then on the wish list is, going all the way up and combining those double roads.
My understanding, Commissioner, is there's 2 relevant criteria. One is the total value of the right-of-way being acquired. And then, of course, that's very much interrelated with the scope and the size of the area being acquired. So, for example, if you're acquiring 100 feet or 200 feet, that was both very wide in area but also very valuable, that could require board action.
Okay.
Moving on to action item 10, it was a request to amend the lot line adjustment application to include realignment of the lot line of the open space further south. And essentially what that means is this is the existing configuration here on the left, and on the right is this is a staff exhibit showing moving this open space conservation easement further south onto the retreat center, which is currently zoned institutional. As I said, this is a staff exhibit. There were conversations that the applicant had with the monastery. Of course, this is not a decision that New Urban West would dictate. This is a decision of the monastery, and they have expressed that there is not a desire to move that boundary further south. They would like to retain that as a open space buffer that currently exists now. If the applicant from the monastery wanted to speak to that, we can ask them to come forward as well.
Yeah, if they would. Gary, can this wait till your...
Well, it goes directly to what Mr. Frankel said.
But I don't want to rebuttal here. I'll let you
Okay.
speak and you can say it, because I'm going to let you, I'm giving you plenty of latitude with,
I understand. I understand.
Okay, cool. Yeah, sorry. Go ahead.
And we
Thanks.
have a representative from the retreat center.
Thank you, Commissioners. Mike Cunningham, Retreat Center Director, Madre de la Rosa. As stewards of the land at Madre de la Rosa for nearly 100 years, the Passionists recognize the importance of conservation. The Passionists have carefully considered the request to change the boundary of the conservation area. We respectfully request that the development agreement remains in its current form. Our ministry requires solitude, privacy, and control of all the activities on our grounds. This includes the area immediately behind the retreat center. Having the opportunity to use portions of the area north of the retreat center provides the ability for us to respond to the needs of the ministry in the future and is essential to protect the integrity of Madre de la Rosa. The Passionists believe that dedicating 35 acres of hillside land for preservation and a 3.5-acre park are a significant public benefit, and we remain committed to ensuring this benefit is secured on behalf of the citizens of Sierra Madre. That's why we've agreed to execute the conservation agreement earlier in the development process in order to provide additional assurances that the hillside protection will be completed. Again, to ensure the protection of our operations and ministry, the Passionists would respectfully request the agreement remains in its current form.
Can I follow up with some questions? I'm a little confused about the buffer concept, because I get the buffer that we saw in the prior slide, the candy cane area where you're buffering, you know, what you guys are doing from the new houses, but I don't understand buffering from open space.
Well, the buffering is directly behind the retreat center, and we do have people that infringe on that property on occasions. It's directly behind all of the rooms and the back end of the stations of the cross. So we're really just trying to protect that whole area for the future.
But I mean, are you planning on putting buildings there?
The area, there's a large portion of that area that we would consider. It's not an area that we intend to build any habitable dwellings. Let me put it that way. And you can tell just by looking for the contours of the upper part of that area that you've got marked there. So it's not our intention to develop that area, you know, right at the right in the upper area of that segment. However, we want to make sure that whole area is a buffer area for our retreat activities. We do have activities in and around that area. That's an access area also for vehicles and emergency vehicles, and so we need to keep that space. In the same way as we've spent a lot of time dealing with the buffer area at the front end where we interface with the development, we have to do the same thing at the rear end. And you know, we're quite happy to do what's required to put these the larger areas further up the mountain into the conservation easement that we've discussed, but we want to protect the area directly behind the retreat center.
I guess I'm still a little confused, because what we're talking about is you've got 3 parcels on here. I guess that's an issue we'll get to later if there are actually 3 parcels, but let's assume that there are 3 parcels now, and you did a lot line adjustment, so you had the retreat center, the project site, and the hillside area, and that was zoned for hillside. You'd still own it, you'd still be able to use it, you'd still be able to do, I mean, you could put stations of the cross and hiking trails and things up there. You just couldn't build buildings. So I guess I'm not following the buffer concept here, because it seems like a parcel of land that you own that's zoned open space sounds like a great buffer to me. So it doesn't, I guess that's where I'm at.
Well, we've had a lot of discussion about this internally at all different levels, and you know, we feel like we are making very significant donations to the city as a part of this project, which we're we're happy to do so, but we have to draw a line somewhere.
Would it be possible that you said you didn't want to build up there, is it possible you were leaving that open just in case you did? There would be a structure that would then require, you wouldn't be able to build in the open space?
Well, the sorts of things that might be developed in the areas that have the higher elevation might be, things like a shrine or a prayer meeting area or that type of thing. So we certainly would be open to a discussion about limiting the development of habitable buildings in the upper zones of that segment, but we really want to try and keep control of the whole thing. So we would be willing to talk about maybe some sort of encumbrance on ourselves that would limit that, if that would make the commissioners more comfortable.
I'm not talking about taking away your control. You guys own it. I just think that the correct zoning for that would be open space, and if you looked at the zoning code and see what you can do, I mean, everything you're talking about now seems like you could do. When we went on the tour, I went through the Station of the Cross with you, and I thought it was fabulous. And I could imagine sort of a twin of that going north. And I don't think there would be anything prohibiting that. It's just really more about building. So I think that's enough for now.
Thank you.
Go ahead, Vince.
These next three action items, 11, 12, and 13, are addressing the development agreement. Action item 11 was to include a revision clause in the development agreement that will allow the project to revert back to the underlying zone if the project failed. And as City Attorney Garagosian indicated, that the automatic revision would violate the procedural directions of state law, so that would not be able to be accomplished. He also pointed out that during the second phase of the proceedings, design review and tentative track map, it would require the developer to obtain the track map and the design review permit, and both approvals have expiration dates. And if the developer fails to develop the site within that time frame, those entitlements will also expire and would be required to be turned to the city to obtain further approvals. I'm gonna go ahead.
So, I guess to me that sounds different than what Mr. City Attorney said to us earlier, or what I heard. I thought that what I heard said was that once we approve this as a specific plan, that stays with the land forever and always. But this is saying that those expire if the permit lapse.
If the development agreement or if the tentative track map doesn't proceed and the design review doesn't proceed, those entitlements could expire.
But those entitlements are just the development agreement, right?
Yes.
I mean, if we change the general plan and the zoning, that's permanent. At least that's my understanding. And City Attorney, please weigh in.
Right. I think everything everyone said is correct. The specific plan and general plan, so it's not permanent. It's only in place until changed. But we can't automatically change it. We can't include any provision that would automatically cause it to revert back to what the underlying zoning was. But yes, once changed, the specific plan, the general plan, and the zone change would remain in place until the proper procedure that you all are following now is followed again to change it to something else. The tentative, however, as pointed out, the tentative track map and the design review permits, those are subject to timelines, and the developer can't develop that land without those approvals. So that would guarantee that essentially the property can't be developed unless those are issued. And if the developer doesn't build in a certain amount of time, then they would have to come back to get those approvals again from the city, which is a huge disincentive for the applicant.
And so, just so I'm perfectly clear in my understanding of it, hypothetically, the timeline expires and the tentative track map and design review permit go back to the drawing board, but the land will continue to be bound by the specific plan that was adopted when we changed the zone.
Correct.
But another developer could come in and go through this entire process again to make it something completely different? Is that possible?
They wouldn't go through this specific plan process. I mean, they could potentially apply for an amendment to the specific plan, and that would be up to this body to decide whether they want to recommend approval to that or not in the future. But if the tentative track map and design review permit expired, the specific plan, if approved, would remain in place as approved, and the applicant would have to go through the whole process of design review permit and tentative track map again.
But what if a developer came in and said they wanted to make it institutional in the sense that it's, you know, something institutional?
I'm sorry, Commissioner Dallas, you'll have to speak directly into the mic.
What if a developer came in and said, no, this is like a perfect school site? Could they go through a whole new rezoning process?
They could not. They could not develop it as a school site. They would have to amend the specific plan.
So we'd have to go through this whole rigmarole in
Yeah.
reverse, basically.
Yeah, but then it could become a school.
Yeah, but it's a big.
Yes, it's a big deal, but it's not impossible.
No.
Yeah.
Yeah, there's nothing you do today cannot be undone at a later point, but the process will have to be followed.
Some other planning commission.
Action item 12, unless there's additional questions. Action item 12 is to consider amending the development agreement to have the applicant provide the city with a conservation easement earlier in the process and for the city to forestall recordation until after all entitlements are issued. The applicant has agreed to execute the conservation easement upon approval of design review permit and tentative track map. And the conservation easement will be held in escrow and recorded upon issuance of the 10th building permit. So these are both improvements, and the city attorney could elaborate on action item 12. If you desire. And do we have questions on action item 12? And this was a request from the Planning Commission. I believe originally the conservation easement was to be recorded upon the issuance of I believe it was the 22nd building permit, so that's been reduced to 10. And it's done earlier in the process. Seeing no questions, let me go on to action item 13. To include more language in the development agreement regarding bonds for residential improvements such as performance, surety, and construction bonds. The applicant has also agreed to amend the development agreement and require performance bonds for all improvements.
And I'll just clarify that before in the development agreement, we had not included bonding for construction of a public park, and it's been amended to include bonding for the construction of public park as well now.
Two more action items to go. Action item 14, the commission asks for clarity regarding public comment, claiming that the lot line adjustment is the proper procedure to create Parcel 1 and Parcel 2. Staff reviewed the public comments submitted on this item and did conclude that a lot line adjustment is the appropriate procedure. We consulted with our consultant who prepared the lot line adjustment. We asked if the merger was the appropriate procedure or the lot line adjustment. He concurred with the lot line adjustment. He also researched the records that identified the parcels that we're looking at as lot line adjustment as 3 legal parcels that are tied together. And that was the ultimate position, and the city attorney will eventually be publishing a memorandum outlining the city's position regarding this issue. The last action item is number 15, and the commission requested that the city attorney provide an opinion regarding recirculation of the draft environmental impact report. Staff reviewed the public comments submitted on this item and concluded that recirculation is not required, and again, the city attorney will publish a memorandum outlining the city's position. That'll be a public memorandum. That concludes my presentation.
Any other last questions, or you want to break? In a minute.
We're gonna open it up to them?
Yeah, in a second. Yeah, I'm probably gonna let Mr. Basile speak, because he's gonna get an extended period of time, and then we'll take a break. But
Yeah.
you have some questions.
I have a question on and this may be more on Bailey Canyon than the new park, but a question on closing of parks. And the Bailey Canyon currently is fenced in and closes when it's not open. Is that the plan for the new park? Are we going to continue that on Bailey Park? And I noticed that I really thought the suggestion alternate 2 on the sidewalk to save the trees is a good one, but that goes a lot into Bailey Canyon, and I'm assuming if that's a public sidewalk, you couldn't gate it off.
Correct.
So
the Bailey Canyon Trail is accessed through Bailey Canyon Park. So the trail is what we want to close because it crosses a debris flow.
Mm-hmm.
And so it is closed on rainy days, or days when rain is anticipated, because we had that father and son killed when they were hiking up there, and the debris flow, washed them out. So I don't doubt that the access to the trail is a single gate area, that could be modified so that the trail would be closed on rainy days and the park could stay open. That's entirely possible. And therefore the sidewalk would be through a public park that is open during the day, and I guess in the evening too. Most of our other parks are open in the evening, but we could, that'd be up to city council or somebody to decide whether they want to keep it open or closed.
yeah.
The fact that it would be ADA accessible, I think is a good step forward.
Yeah.
Because right now it is not. But the only reason you close those gates at where Grove intersects, where into the parking lot, is because you don't want people accessing the trail as opposed to the park itself.
So we could potentially move those gates up to the trailhead and then have the Bailey Canyon Park open and the new park open.
The 2 stone gates?
I'm just saying, wherever it is that you would put a gate to close off the trail so that you could have those parks open.
Yeah, the hard part is that the access to the trail goes through the flood control right-of-way. And so controlling that may be, right now it's only one little gate that you go through after you go through the park to go up to the trail. So you could modify that gate and you'd be fine. Depends on where the other access point is from the development to get to the trail. But that would be two gates to close, and they could still do that. I mean, that's not a insurmountable challenge. But the only reason why it's closed now is because the trail crosses a flood control debris flow.
Okay.
All right, very good. All right, so at this time, and we may interject other comments or ask questions of the applicant unless, do you have anything you want to say at this point, Ms.? Okay, great. So what I'm going to do is I'm going to open it up to public comment, and I promised Mr. Basile that Ms. Grossman-Palmer could be able to speak, and I'm going to give her an extended period of time he's going to be speaking on her behalf. So what goes for him in this initial does not go for the rest of everybody else.
Thank you. I appreciate it. Thank you, Commissioner Presner. Thank you, Commissioners. It's good to be with you here tonight. My name is Gary Bossio. I reside at 630 Fairview Avenue. And for clarification, I want to let you know that Ms. Beverly Grossman Palmer, who is an attorney that Protect Sierra Madre has retained, was not asked to be here in that we were not sure that she would be able to speak until there was a consensus, which you had at the beginning of today's meeting. So without risking her driving from the west side to be here to possibly not speak, we decided it best not to have her here today. And I am going to speak kind of on her behalf, and as well as on my own behalf, and as a committee member of Protect Sierra Madre. I'm also an attorney, and before I speak as to what she was going to speak to, I'd like to just quickly clarify something for the commission as to what Mr. Frankel said about the acquisition of the county property from the County of Los Angeles. The County of Los Angeles has been a client of mine for 25 years, so I know quite well what the Claims Board and the Board of Supervisors has to do when they approve either a settlement or an acquisition or give property to another entity. And that threshold is $100,000. Anything between $20,000 value and $100,000 value must go before what's called the Claims Board, which is a 3-member board. Anything with a value above $100,000 must go to the Board of Supervisors. So the fact that this is not a pro forma item that the Department of Public Works can just sign off on, if the value of that land is valued at more than $100,000, it must then go before the Board of Supervisors. So I wanted to clarify that for the Commission because I think that is an important point. What I'd like to do is...
Yeah, I was just...
Go ahead. I'm going to let
Yes.
this...
Is that value determined by appraisal, or can the board, or can
My understanding
the
is
county agree to that, or?
My understanding, it's determined by appraisal.
Okay.
Right. And I don't have any idea what that value of that property would be. It could very well be below $100,000. It could be much higher than that. We just do not know. Now, as the Commission knows, when the final EIR came out, Protect Sierra Madre retained Ms. Beverly Grossman Palmer, who created a rather lengthy letter with a lot of documents attached. I'm not going to regurgitate that. That would be an impossibility here tonight. One day later, New Urban West retained a firm to rebut or respond to that letter. And what I'd like to do tonight is, and you should have been provided the letter earlier today, you may not have, but Ms. Beverly Grossman Palmer responded to the rebuttal by the Manette firm, and I'd like to read that 2-page letter to you. Dear members of the Sierra Madre Planning Commission, on April 6, 2022, this firm provided a letter on behalf of Protect Sierra Madre, explaining how the public has been denied the opportunity to participate in the environmental review process for the proposed Meadows at Bailey Canyon project, to which the public is entitled by the California Environmental Quality Act, CEQA. Our 149-page letter explained how the final environmental impact report increased the 17.3-acre footprint of the project by widening a portion of Carter Avenue outside the original project site, and how the public had no opportunity to weigh in on this substantial change, despite the fact that it will indisputably require cutting down a copse of mature trees that provide support for a very steep erosion risky slope. Because of these changes to the disclosed scope of the project, the letter explained that recirculation of the EIR for additional public comment is required. The letter also documented multiple factual and analytic flaws with the environmental review process to date and walked the commission through why the project, despite the developer's request, does not qualify for a lot line adjustment and compliance with the Subdivision Map Act as required. To support these contentions, the letter provided pages and pages of analysis, meticulous citations to the draft and final EIRs and their various appendices, and even pictures and exhibits. One day later, through a letter from Manette Phelps and Phillips, law firm hired by Newman West, these concerns were brushed off without addressing them at all. This silence is deafening. If the developer and their counsel had a good reason why the draft EIR made no mention of improvements to the portion of Carter Avenue that lay beyond the 17.3 acre parcel, despite the fact that this aspect of the project had been known to the city and developer as early as September 2020, they would have said so. If developer and their counsel disagreed with the letter's observations about factual errors in the environmental review, such as inaccurately characterizing the mature trees that would be removed as being located on city property when there's no dispute that they're on county land, then they would have said why. Nor does the response provide any basis to support the critical weakness of their request. The title record is clear that this property is a single legal parcel. The applicant's 3-parcel drawing is a fiction that has no basis in the legal documents that have accompanied every transfer of this property for more than a century. The applicant's silence on this issue is telling. The EIR's errors and analytical gaps have compromised the credibility of the entire final EIR as an accurate and complete analysis of the environmental effects of the proposed project and have precluded the public's ability to meaningfully participate in the environmental review process for the largest housing development in Sierra Madre's history. The public deserves better. Recirculation is required because the EIR fails to meaningfully disclose or discuss impacts of the project off-site in county-owned parkland. The public and local government agencies were deprived of an opportunity to comment on this aspect of the project. When a local government certifies an EIR under CEQA, it is required to exercise its independent judgment based on substantial evidence in the record. The government body must be able to conclude that changes or alterations have been included in the project to mitigate the significant effects disclosed in the EIR, or that these are infeasible. The adequate EIR here will make this finding impossible to support. As our original letter stated, the Planning Commission should proceed with great care. Approving this project on the basis of the EIR and granting the illegal lot line adjustment would be a serious legal error. Instead, this commission should require revisions to the EIR and recirculate it to allow proper public comment and input from relevant agencies who were otherwise sidelined in the process. And secondly, deny the lot line adjustment and require the developer to proceed in compliance with the Subdivision Map Act. Very truly yours, Beverly Grossman Palmer. Thank you, Chair Pevner and the remaining commissioners for your time tonight. Thank you, I appreciate it.
Thank you. Bob, questions or a comment? You want to say something? No? You're looking at me like, no? All right.
Well, in the final EIR, doesn't it cover the Carter Road sidewalk?
Well, that's what we're.
I don't know who to believe at this point.
Well, I know. I think what I'm going to do is I'm going to take a break and let other people talk, and then at some point, if you want to, we can have the applicant come back up and answer some questions. I don't really want to get into a back and forth debate, but I do want to be able to clarify things, and we may have to actually ask the city attorney for some clarification if the planning director doesn't know the legal aspects of it. Okay, so hold tight, or you can take 10 minutes and we'll come right back. Thank you for your patience.
No worries.
Okay. I was gonna give him 15 minutes. She showed up. I didn't get, did you see the letter that?
Her complaint was that the lot lines in Carter Avenue were not fully.
No.
Well, the lot line is a different issue than secret. Entirely separate.
Yeah, that's what I thought.
Entirely, we'll talk about that later, but,
The one.
the recirculation is, I mean, what's significant, you know?
Yeah, the word significant was the one that
Okay,
jumped out.
thank you. All right, thank you. Yeah. But that's it. Thanks, I'm the hall
I'll take one to Bob.
Okay, I'm the hall monitor, you have to pay. Yeah, what's this? Oh, it's a big, I get the one in blue.
Oh, you're so special.
Yeah.
Really stifling the urge to put a mustache on
How about just a post-it note? Get a post-it and cut it like one and then.
Exactly.
You've got a lot of post-its there, don't you?
I give post-its for.
Yeah, I try not to get caught up into things. Did you see, well, you only saw some of the emails from Mr. Basile to me and to the,
I saw very few.
yeah, Alex sent a summary of my first refusal and then his rebuttal and then the back and forth and then, right. Right, and so what you didn't see was a lot of the back and forth from him to me, which I was trying to avoid. But since I had to be the person to answer, Alex just said, he gave me advice, and then I just fired. And then eventually it's like, yeah, it's like I acquiesced, because he kept asking me if she should. But he did tell us the truth. He said that she was going to show up anyway to talk at either the community input or this time, depending on front. Exactly. Well, because as soon as it looked like he was going to get his way, he then said, well, he had a, because sure she was going to be able to speak because this is going to be very expensive. Oh, okay. I'm sorry.
I can't hear you.
You can? Oh, no.
Never know, right now.
Look at my wife wants to talk to the meeting. Yeah, would you like to speak at the meeting, sweetheart? Oh, okay. Bye. Okay, thanks. Bye.
Are you getting rated from home?
That's my wife saying, I can hear you on the microphone right now. Hi, honey. Listen. Here, I'm putting it over here. That we could send them to you? Oh my goodness. And then, that's where you live.
The second lot up there, it's not in Pasadena, isn't that an unincorporated LA?
It's unincorporated, but under Pasadena.
Okay, I just wanted to talk about.
Oh, you do? It is? I don't know, my wife just called me and said she could hear me. That's okay. I will leave it over there until we start talking. Okay. I don't hear him. I'll say this public. But that's what I want to know. You didn't hear all of it. That's why I didn't want to get too much. Yeah, but I know. Really unified to get that. All right, we'll go ahead and begin again for public comment. If everybody wants to come inside and have a seat, thank you. All right. Okay, looks like we're back live. So we'll continue with public comment. Anybody now can speak on this matter. I'm going to limit 2 to 3 minutes because there's a whole bunch of people here. So do we have cards, Jen? We do. You want to call their name?
Alex Arrieta, and after him will be Manuel Valencia.
Good evening. Again, Alex Arrieta. I wanted to kind of follow up further on what Gary had spoken about with the draft EIR. And, you know, when I look at the agenda for this evening in terms of, again, I have the utmost respect for this governing body, but it's a rather audacious agenda in terms of what you're being asked to consider with certifying the environmental impact report, approving a specific plan. And I'm very concerned because on multiple meetings, this body continues to ask for specificity in the specific plan. And I know there's been repeated requests for that. So I do not see how that can even be considered to be approved without having that degree of specificity included. Approving amendments to general plan, lot line adjustment, development agreement. These are all, I mean, you could take one of these and have significant debate about it and still not complete it, much less 5. I'm very concerned about the environmental impact report even being considered, that it could be finalized and ratified with all the significant concerns that have been already communicated, including around the lot line adjustment, including the issue around Carter. And you know, I wanted to reiterate, the issue around Carter was something that was contemplated in March 2020 when the original MOU was developed. Developer, the applicant, they knew back then that that was an issue. And so for that not be included in a draft EIR, it's just disingenuous, it's inappropriate, and it's unprofessional. And so for that, and the public clearly had no opportunity to provide input or to provide opinion around that. And it's significant enough that it warrants recirculation of the EIR and to receive the appropriate level of public scrutiny and public involvement and input. Beyond that, there are significant errors and analytical gaps in the EIR that just do not make it valid. Valid to the point where the governing body like yourself can seriously review and consider ratifying it. It is so far from that level. So I strongly advise that you not approve the current EIR in its form and request that it be recirculated. So the public can have the opportunity to weigh in on some very significant matters still. This final piece I want to talk about is around fire. This remains to be contemplating building 42 homes in the highest fire zone in the city. And as I've spoken about before, it just doesn't make any sense whatsoever to consider that in light of the building materials that are going to be used to build these homes are the same type of building materials that went up in flames as recently as 3 years ago in a 10-house development in Ventura, because it was sat in a similar type of wind tunnel that Beasley Canyon is right at the base of the monastery. So I'm very concerned about that we're even considering building homes in this area. Thank you very much.
Thank you.
Good evening. My name is Manuel Valencia, and I want to thank you for allowing me to spend a few minutes to share some thoughts. I'm not qualified to go into details of EIRs or legal issues, except to say that I have the utmost confidence in the Planning Commission. Your questions have been exhaustive. They've been to the point. They are specific. They are tough. And I do believe that by the time you conclude all of your deliberations, that you will be able to come up with something that is going to result in something that is good, and certainly for the common good, the people of Sierra Madre. I do believe that. I believe that I bring two very unique perspectives to this issue of the proposed development. First, as a resident, Sierra Madre has been home to my Valencia family since 1962. I was 13 years old. Don't bother doing the math. I'm an old guy. My parents moved here with my brothers and sisters. They went to St. Rita Catholic School, later on LaSalle, Alverno. My wife and I have lived here in Sierra Madre. We have owned our home up in the Lower Canyon, 284 Old Ranch Road. We've had that home for nearly 40 years. We raised our two children there. St. Rita's, Alverno, LaSalle. We have roots here in Sierra Madre. This is my home. I love this place. It is charming. It is quirky. It is a city with a lot of people with strong opinion, strongly expressed. And by the way, to the gentleman who was upset about someone who put flyers on his, on his door at 5:45 2 times in a row. You know what? Yes, it may be legal, but I get you. It can be annoying. And I think I would have been annoyed too. So I just want to make that point. But having said all of that, I want only the good for Sierra Madre in the same way that everyone here I know wants the good for Sierra Madre. Secondly, my other perspective has to do with the Passionist community and Mater Dolorosa Retreat Center. I have known and have been close to the Passionist community, almost as close as I have been to my own blood relatives, my own family. I entered the Passionist seminary and studied with the Passionists for 5 years, 5 joyful years, 4 years of high school, 1 year of the novitiate. Many of those who are professed brothers and priests were classmates of mine. Father Mike Higgins, Father Clemente Barron, Brother John Rockenbach. They are like older brothers, maybe not much older, but older brothers. That is how close I am to them. My wife and I were part of the weekend retreat ministry for 19 years. I am an ordained deacon in the Catholic Church. I was part of that ministry until June of last year. I know the Passionist community, and I do love that quirky community too. The Passionists are residents of this city, and for nearly 100 years they have been great members of this community. They expect to be in Sierra Madre for another 100 years. I also, as with you, I have the utmost trust and respect in the proposed development that they are proposing.
Mr. Valencia, I'm sorry, it's your 3 minutes.
Okay, I just want to say that I respect what you are doing, and I trust what the Passionist community is proposing in this development.
Thank you.
Thank you very, very much.
Philip Yao, and then Filippo Fanara.
Hello, Philip Yao, 513 Sierra Keys. I'm actually, thank you, Commissioner Dallas. When you walk the area, I'm in one of the houses that's abuts the southerly property line. That you recall seeing about an 8-foot retaining wall. So if there wasn't a fence there, people could be in serious jeopardy. Okay. Anyway, just to refresh, last meeting I brought to you some information on biodiversity. I handed it out. It is a problem throughout the U.S., but more specifically in California. Okay. So I'm going to just say a couple of things. Meadows development is really a bad biodiversity deal for California and for Sierra Madre. A very important thing that we're really going to have to start addressing. So much so that the state, the governor has issued an executive order, N-82-20, Nancy-82-20, and it was signed off in October 2020. I really welcome you guys to take a look. It is something that affects all of us, okay, all of us. Meadows will worsen the traffic in the surrounding neighborhood, okay? More specifically, Sunnyside. And I'm going to bring one example, having canvassed the neighborhood for what we're trying to do. The Highland and Lima corner there had witnessed a fairly major accident. The car took down a power pole and almost took out the resident on the southwest corner of that. By no more than 3 feet he survived. Okay, and that is caused by traffic around that area, which he witnessed and has noted increase in speed increasing as well. Okay, the Meadows project violates our general plan. I'm going to direct you guys to take a look. I know that there's a lot of work done on that and will be throughout the years. L6 says that development that is done in harmony with its neighborhood and preserves and protects the privacy, mountain and basin views of neighboring properties. And you can take a look at the policies L6-1 through 4. Okay? It provides some sort of appeal process for 2 stories. It doesn't like obstruction of views. And then also it has some statements in terms of line of sights into existing property and backyards. That's me. I'm one of those, where there would be clear line of sight into my house and into my backyard. Okay. L7 is the second part of it. It's development that is compatible in its design and scale with the neighborhood. And that talks about lot coverage and so on like that. I think we looked at today the discussion, very nicely prepared, shows the amount of give that the city of Sierra Madre is willing to give up. If you subtract whether you add the garage size or you subtract it, it's about expansion about 2 times of what I could put on my property. And that's something that I'd like for you, the commission, is to take a look at. I know development is coming, but do we actually give up as much as we do? Lastly, I'm sorry, I will give this to you. I forgot to do that. Should I hand it to you? I'll hand it to you. Okay, these are pictures that shows my property and my neighbor's property to my west side and my neighbor's property to the east side. And you can see how much of a problem we're going to have when there's a park there.
Okay.
And it would. I don't have a pool in my lot, in my
go ahead.
in my house, but my neighbors both on left and right do, and I'm sure that they have some concerns with privacy being invaded.
Commissioner had a question.
Oh, yes.
Yeah, I think one of the things about the site tour that was really helpful was actually seeing this exact view from the park down into the neighbors to the south. And I'm, was just thinking about the kind of screening and fencing that we could do to make sure that, you know, random people in the park aren't looking into your backyard?
Well, there's a solution somewhere, I mean, obviously, but I think that prior to your walkthrough of the project site, you weren't aware of, you know, maybe the several times that I previously had appeared, you know, cautioning that we do have a problem. And that problem is an unabated view into a lot of properties along that line. I've only brought to you pictures of 3 houses, and that's kind of taken at a place where I did a panoramic left and a panoramic right, and you can see, and I'm glad that I think Commissioner Dallas was the person that mentioned it was so useful, and you saw the difficulties that the adjoining property owners have. We don't know what to do. We just know there's a problem. And we knew a long time ago, looking at the development, that it was a really big grab for lot coverage. And I think the numbers today show that it is. R1 is a myth, is not R1. It's R1 plus, plus. And that's a real problem, because I have to deal with it.
Okay.
Okay?
Yeah,
So
thank you.
Thank you for taking a look at the picture, and I think if you have any questions, you know, I'm at 513. Certainly be welcome to entertain giving you any additional data from my vantage point.
Okay. Thank you.
Thank you.
Thank you.
Filippo Finara, and next will be Scott Oliver.
Good evening, members of the commission. My name is Filippo Finara, and I live at 1180 Topeka in the city of Pasadena. My connection to Sierra Madre is that I'm the head of the board of directors for the Passionist Retreat Center. So I don't envy your job. You guys have got a tremendous amount of work to do in order to adjudicate this application. I've heard about traffic. I've heard about water. I've heard about fire zones. I've heard about the number of people that will be moving into this community. Regarding traffic, I would look at if the number of the people that have spoken up here tonight have been here for 30, 40, 50 years. And I guarantee you, I would surmise that when they came to live here, it was a very different place than what it is today. And it'll be a different place tomorrow, because we live in a large metropolitan area that requires that unless we put guards at the borders, we're not going to be able to stop the number of people that are moving to California. When they talk about water, that it seems like we don't have enough water in the metropolitan district. Well, where do you think these people live now? They live in Southern California. They're just going to move to another area, so the water is going to be here. Some way or other, water will come to this area, because unless we stop people from moving into California, you're going to have the same problem. Traffic, and again, I reiterate that it was a very different place when you moved here as what it is today. So we, again, live in a very large area that has a lot of people. I moved here as a kid when I was 9 years old from a different country, and I guarantee you that what I experienced at that point, you can't go from one side of the city to the other. If you have an early appointment on the west side, you might as well take out a hotel room the night before, because you're not going to get there early in the morning. It just doesn't work that way. We have a lot of people who live in Southern California. So I would say, you know, these are additional people that will move into your community. They're not coming from other states. They're coming from this particular area. I thank you very much for your time. Have a good evening.
Scott Oliver, and then Alice Wichello.
144 West Carter, just like before. First, I want to thank you, commissioners. As I've spoken many times, I've often referred to you as our community representatives to protect us. I've asked you, please do what it is your job. My main concern at this particular time, I can't really speak about specifics in 3 minutes. I'd like to reiterate what Gary said. The EIR, I think, is definitely, or most obviously, flawed. the way I would try to look at it from a gut perspective, if I was one of you, is, you know, the money on this project, just at today's values, and even on a conservative side, calc out to about 120 to 160 million dollars of potential gross revenue. Obviously, the church is going to get a very small portion of that, and the more the project makes, I assume the more they would get, and that's their benefit. But the big lion's share, you know, maybe $100 million, once again, the EIR, we all believe the EIR protects us from anything that's not right for the environment that the impact would influence. So that's what I would want to kind of urge you commissioners to consider, as Gary mentioned, about the possible liability. With Maranatha, you know, the lawsuits were going back and forth, there was a settlement, it's still not developed. But if this was to be scrutinized later, and this particularly flawed EIR was, as it seems, the city's trying to get it through, the developer's trying to get it through, everybody's trying to get it through, you guys are sitting there going, wait, we gotta read this thing, and this redistribution being denied by the city attorney is not necessary. Oh, please, I'm a member of the community. It's necessary. We need to reevaluate the EIR. You commissioners need to determine if it is truly flawed and needs to be totally redone. And so we can feel that it is doing its job protecting us, because we are the environment. We're part of it. And the impact from a project, calculating out at the numbers I quoted, in 4 or 5 years, it could easily be 200 million, which in comparison would buy our entire downtown section. A project that's being basically sloughed off as just a small project to give some money to the church could be so magnanimous it would be over the size of the community itself. And to be rushed through, it doesn't make sense. So, thank you.
Thank you. Wish Elon Musk wasn't so busy. Maybe
Alice
he could come
Wichello,
see us.
and then Susan Newhousen.
Planning Commission, thank you so much for hearing me. My name is Alice Wichello. I live at 417 Sierra Madre Boulevard. Thank you for, again, being here. The environmental impact report needs to be recirculated due to massive deficiencies with the agency who gave this report with its below average standards of what is damaging to the environment. The state of California is in its worst drought in state history, yet we're all being told to use now 35% reduction in our water. Yet it doesn't sound like a net zero water type of thing to me. We're being asked to conserve water. And I still am at a loss of why in the highest fire hazard area zone of our city, homes are being built there. I just don't understand that. Why all of us, oh no, it's okay. It used to be the most high fire hazard zone in the city, but now it's not anymore. We can build homes there. And one more thing I'll just say, of course, I live in Sierra Madre now and have for 3 years, but I've lived in the San Gabriel Valley my whole life. Sierra Madre is one of the last little quaint towns that's almost left in the San Gabriel Valley, and what it's going to turn into is just another suburb of Los Angeles. So thank you so much.
Susan Newhousen.
Yeah, thank you. Here I am again. Yeah, I also thank you all. You guys have a somewhat thankless task. It's a lot of work. And as promised, Ms. Dallas. So a few of the things that I just noticed and actually then hearing as well. So sort of starting backwards. I think that's a great idea to move the gate so that you could open that up. I think the police might not agree with you because they don't even always unlock the gate now when all they have to do is pull up, and if they have to walk to unlock a gate, it might be a problem. And the deodars, so trying to protect them. I think we all know that when you may not have to cut them down directly, but when you start digging 10 feet in and you have those slopes that you're going to impact them and most likely kill all those trees. I mean, that's just That's just a fact. So I don't think that, you know, pretending that these trees are going to survive is adequate, and I think it really needs an arborist opinion for it. I like that the city, thank you for making that table. I just want to point out that actually if you look in the specific plan in table 3.2, it actually shows that rather than a minimum lot coverage of 50%, which is 10% more than in the general plan, it's actually they have, instead of saying a maximum of 50%, they say a minimum of 50%. So I think that that would be something you would want to make sure was corrected, because otherwise it would allow them to build a minimum of 50% on a lot. When you were talking about square footage and then adding 400 square feet for the garage, you also need to add, all their calculations are based on interior square footage, and so you have to also add either 9 inches or a foot for the exterior walls, which then adds, you know, approximately another 200 to 300 square foot to a house. So there's 3,500 square foot house, you add the garage, you add the exterior square footage, you're up to 4,100 square feet. So it gets to be a lot. And then just, again, you know, reminding you all, which you know, that the specific plan supersedes our municipal code and the general plan, and basically, so it overwhelms the code 17, which is a residential code. So, you know, I've done the math on their 9.2 acres. They could build 15 houses of what their average gross floor area of 4,100 square feet is. If they really want 42 houses of that size, they'd actually need 25 acres of house lots rather than the 9.2 they have, so almost threefold. So, and you guys have figured this all out, and again, you know, the majority of their houses, they've already told us, are 2-story houses, and I appreciate your concern that the fact that the specific plan is so non-specific means that, right, on an 8,000 square foot lot, they could build a 4,200 square foot house, they could build them all the way across. Yeah, your concerns about massing and needing to see what each individual looks like now is important. And one more thing, just because Mr. Frankel, I recall, talked about, well, we can't say who can build what on a certain lot because, you know, then people wouldn't want to buy them. But I think that's actually exactly what you need to do to make sure that you don't have all the, you know, all the larger size houses on all these lots. There's nothing to prevent it based on approving the specific plan. Thank you.
Thank you.
Deb Sheridan, and then Gary Hood.
Deb Sheridan, Valley Vista Drive. You have heard many well-thought-out reasons that New Urban West development falls short and should not be approved in this form. And by the way, I'm speaking about the EIR again, as several people have. They have tried to explain the shortcomings away, but what they can't explain away is the unprecedented drought. And I apologize, Chair Pesner, I'm being a little repetitive from other people, but every day we hear about the lakes drying up. I just heard something else today, and I forget which lake it was, Lake Powell, that is as low as it's ever been, and that there is not any water to be had anywhere. We California residents are supposed to cut our water supply, water use by 35%. We in Sierra Madre have already greatly reduced our usage in the last drought. I lost 3 trees because I couldn't water them. Fire season is here because there is no season anymore. It's all year. And where will be the water to fight it? They say, New Urban West says their EIR, that there is no problem and that our rebuttals were insignificant. And this is not so. So please consider it. Thank you very much.
Thank you.
Gary Hood, and then Nancy Beckham.
Good evening. Name's Gary Hood, live on North Baldwin, and I support 100% with what Alex Aliata said regarding the EIR. Thank you for listening to the public.
Thank you. Sally Shore. And John Doyle next.
Good evening. My name is Sally Shore. I live at 634 West Sierra Madre Boulevard, and I also speak for my mother, who lives at 501 Crestvale Drive, which many of you walked by. And I brought a handout because I'm going to speak to a very particular but important point about view blockage. We are very, very concerned about the parking lot and the park being built, but the answer is not to diminish my mother's property value by building the proposed slump wall, which is in violation of Ordinance 1720-010 and subsequent matters. If you look at the first drawing I brought, you will see how that wall would prospectively look from the front of the house and adjoining. If you look at the following drawing, which is an artist's rendering, this proposed slump wall is a minimum of 3 feet tall with trees, which will fully block the existing view and lower the property value. And the developer proposes the wall that will be up to 8 feet. And then if you look at the final slide, this is the view as it currently looks before the development. There is no provision to compensate property value diminishment for the adjoining neighbors. We question the value of even having the park and the parking lot. The parking lot is currently designed to be built directly behind my mother's house. We would ask that it be reevaluated and considered maybe some more sort of a natural, more Bailey Canyon-like, which would provide a similar buffer zone that they are making for Sunnyside. And I also want to first thank all of you for expanding the comment time, but I want to comment. I'm a paralegal by trade. I worked for Latham & Watkins for many years as a land use paralegal preparing EIRs. I worked for the Staples development, the Hollywood Bowl expansion, and the Disney expansion. And I'm kind of surprised that my colleagues at Manat have not encouraged the developer to have a substantive meeting with adjoining property owners. It does not happen. We occasionally receive some of the marketing flyers, but they don't approach us with the same energy that they seem to do with the marketing to the community. There are many issues that need to be resolved and discussed. My family did have an initial conversation with the developer, but most of our questions have gone unanswered since we spoke back around April 22nd. I think that the only seam that seems to work is maybe to have this EIR refined and recirculated so that it addresses property value issues for the residents who live here, like our family who's been here since 1963 and went to Sierra Madre Nursery School, Sierra Mesa, and Sierra Madre School. Thank you so much.
John Doyle, and then Father Clemente Barron.
Good evening, members of the Planning Commission. My name is John Doyle. I am an author and retired attorney and have been a homeowner in Sierra Madre since 2009. I'm also a member of Sierra Madre CERT. First, I want to thank the commissioners for the many hours you have spent and will spend in evaluating the Meadows project. This, I believe, is the 5th public meeting on this issue, which doesn't even take into account the hundreds of hours of review and preparation you have spent as a group. I commend you for this important volunteer work and for your careful efforts to get this one right and avoid the pitfalls our city experienced with the One Carter Avenue project and the Kensington project. I support the Meadows because it will benefit our city and will avoid probable alternative outcomes which are much less desirable to our residents and neighbors. It is compelling to me that state-mandated multiple-unit low-income housing with no input from our city, or an institutional project such as a large private school or senior assisted care facility could be built if this project is not approved. This project is a much better fit for Sierra Madre. There's been some mention that this project is in a fire zone. Well, first I'd like to mention that there are many, many homes in Sierra Madre that are built much farther up the hills and canyons in fire zones. The EIR itself talks about fire protection and talks about the fact that because of the materials and the fire hardening that these homes would be built with, the fire resistant landscaping and fire protection systems, the incidence of wildfire would be reduced, the heights of the flames would be reduced, and this project actually would protect surrounding properties. The proposed development will honor the property rights of the current owners and will provide much needed housing in our city and region. There's a huge housing shortage, and this will help put a dent in it. This will benefit our local businesses, our charitable volunteer and social organizations, and our schools and churches. Finally, the project will enable the monastery to continue and expand its important work in our community and allow the Passionists to support their elder members in a dignified way. It is time to make a decision. Thank you.
I have a question. What's your address?
636 West Sierra Madre Boulevard.
Father Clemente? And after him will be William Park.
Good evening, members of the Planning Commission of Sierra Madre. I'm Father Clemente Barron, a resident, a voter, and one of the owners of the 700 North Sunnyside property. And thank you for this opportunity to share a few thoughts with you. The first time I spoke to the city officials in this chamber was in 1991. At the time, I was the local superior of Madre de la Rosa Passionist community and dealing with the aftermath of the Sierra Madre 5.8 earthquake on June 28, 1991. The monastery was the community residence at that time for 12 Passionists, priests, and brothers. The earthquake severely damaged our home, and after the monastery was condemned and declared unfit to live in, we Passionists sought permits from the city to demolish the building. Much to our surprise, it took us some 9 months for the city to grant the necessary permits, despite the documentation from structural engineer firm whose owner lived here in Sierra Madre. And a group of concerned citizens did not want us to demolish the monastery because they would change their landscape view. But after the demolishment, we converted the area where our home stood for some 60 years into beautiful gardens. In fact, most of the time, this is where we find the bears, the coyotes, the deer, and other wildlife. I cite this now because we have asked the city to rezone a small section of our property for development because some have stated and written that we Passionists are not fully committed to staying here in Sierra Madre. We Passionists number well over 2,150 members in over 60 countries worldwide, and each entity is independent but under a superior general. We have no intention of leaving our land here in Sierra Madre. We trust that you will fulfill your responsibility to make decisions about our property based upon the documented studies and certified reports that have been submitted to you in a timely manner by our partner, New Urban West. We all have had the patience of Job, as we've heard many hearings on this matter before us. We trust that you will have the best information on hand and the best interest of the city as you make your recommendation. So blessings on your service to the city of Sierra Madre. Thank you so much.
Thank you.
William Park, and then Robert Jurdy. Robert Jurdy? Thank you.
Hi, thank you for letting me speak. I want to see the city get the best deal it can out of this. On the conservation easements of the 37 acres to the north of the Meadows project, it should be structured to best serve the city and meet the goals and objectives of the general plan. The MOU stated that the open space hillside land north of the retreat center would be dedicated to the city, and those recitals should be upheld unless there's some reason they absolutely cannot be kept. At the April 7th Planning Commission meeting, the city attorney mentioned having talked with the Sierra Madre Mountains Conservancy a year and a half ago, and that they declined to have an easement recorded in their favor. This is perplexing, since that is what they do. The issue needs to be revisited. As far as I'm aware, the Sierra Madre Mountain Conservancy holds the conservation easements for all conserved properties in the city, totaling over 1,200 acres. I asked the president of the Conservancy what their position was, and she said that as a 501c3, they were neutral on the Meadows project. I think we can trust that they'll remain neutral as a conservancy, even though a number of their board members are actively opposing the Meadows project. It was stated by the Conservancy that, with one exception, land to be placed in conservancy has been dedicated to the city of Sierra Madre, while the Conservancy holds conservation easements. This arrangement is how the city's best interests are served for the general public. What the city should be obligated to do is follow the recitals of the MOU and the goals and objectives of the city's general plan, which in numerous places talks about protecting and being responsible stewards of the neighboring San Gabriel Mountain foothills, wildlife, forest, open space, and other natural resources, and that parkland and open space should be preserved and expanded when possible. Summarizing the objectives and policies of the general plan, the city needs to not only increase open space, but expand its own parkland. In other words, it needs to be owned by the city to benefit the public through conservation easements held by nonprofit conservancies, ideally the Sierra Madre Mountain Conservancy. The city needs to own this land, and the Sierra Madre Conservancy needs to be the neutral third-party conservancy overseeing it in perpetuity. It is important to understand that the city is not necessarily a neutral third party holding a conservation easement, since it has both the power to change land use policy and enforce conservation easements, or not. Or, if for any reason the Sierra Madre Mountain Conservancy abdicates their duty to protect open space in the city, then the conservation easement should be held by a state conservancy. The city should not turn down an opportunity to expand parkland, especially when it costs the city nothing to do so. If the property title is held by a private party like the Passionists, then there's no guarantee of future public access or that parkland will be expanded. Passionists have already agreed through the MOU to give the property to the city as a concession, so why would you turn that down? This agreement should not be changed just because the Sierra Madre Mountain Conservancy might not want to have the easements recorded in their favor. The 17 acres section of land located in unincorporated Los Angeles County can also be owned by the city and held by the Sierra Madre Mountain Conservancy, just as the Conservancy has done with the 920 acres of the Sierra Madre Historical Wilderness Area north of the city in the Angeles National Forest. The city owning the property will give future city councils the option to further protect the land by expanding the Bailey Canyon Wilderness Area across these properties and allowing public access for recreation should it choose. Please structure the development agreement to best serve the residents of the city. Thank you.
Thank you.
Ed Miller?
Hi, I'm Ed Miller. I live at 397 North Lima Street. Really wasn't planning on coming, so I hope my thoughts are not disorganized. But I was honored to serve on the General Plan Steering Committee with one of the commissioners here and a member of the City Council. It was a lot of fun. It was a lot of hard work. We spent 5 years working with the community, having meetings in local neighborhoods, canvassing, polling, and the results were the general plan, which really I think does a good job of capturing the desires of the community in terms of a lot of things, what defines Sierra Madre and the kind of place we want to live in. I also want to say that I fully support the right of the Passionists to develop their properties. They're private property. They have a right to develop it. The thing is, when they want to do something that's different than their current zoning, which is institutional, then it becomes a matter for the city to decide and for the impact that it might have on the city. I reviewed the EIR, the draft EIR, found lots of things in there that were shocking to me, that seemed very much in opposition to the kind of things that we were seeking in the general plan. And then in the specific plan in particular, just listening to, I also went through it myself and found many things that are counter to the general plan. Even before the general plan, there were other efforts by the city that declared it I think a wildlife sanctuary. So if you go back in history and you look at what things we put in the general plan and what the city in the past has declared as the things that we care about, there's just a lot of things in both the EIR and the specific plan that go against that. So I guess what I would ask the commission is, why even consider? There's a California state law that says no specific plan can be adopted unless it's consistent with the general plan. So I'm wondering how we reconcile that with what we're looking at here. I guess the traffic, the water, all of these things are big concerns. They've all been mentioned before. But I guess what I would ask the commission is, why even consider something that's completely different than the general plan? The massing, the lot lines, the angles of the houses. We spent a lot of time going over that to prevent McMansions, to prevent high-density housing. And I think at a minimum, I would request that the council or that the commission reject the current proposal until they come up with one that meets the general plan. I guess that's all I have to say.
Thank you.
Thanks.
That's all the cards that I have.
Oh. Come on up. Well, go ahead. Please. We'll let you. If you didn't speak and you didn't have a card, come on up. Okay, go ahead.
All right, sorry. Thank you very much. Tricia Sarcy, I live at 734 Fairview Avenue, and I'd like to thank the Commission for allowing public comment and granting the community the same deference that you're affording to the developer. The community has a right to expect that the Planning Commission will enforce our laws. Here we have a project that is illegal under our general plan, our zoning code, and violates a list of city policies. State law, as the gentleman before me pointed out, requires that a specific plan conform to the general plan, and this specific plan does not. That's inarguable. Because this commission is considering approving such a project anyway, residents should be allowed to comment all the way through, especially as the specific plan presented evolves and substantively changes in response to questions and concerns. At the last meeting and this meeting, some of you expressed concern that the specific plan is not very specific. The layout is unclear. The boundaries of the project are also very unclear. There's the big problem of the illegal lot line adjustment, the questionable off-site plan, and the tenuous nature of the open space easement. It's also unclear what in the plan could actually be enforced. It seems like all of you are looking for a plan with teeth to ensure that the city and taxpayers aren't left holding the bag when and if things don't go according to plan. And these are all valid concerns and are problems that MIG, the independent EIR reviewer, also identified before they were sidelined for pointing out some of these problems. MIG over and over commented that the specific plan inappropriately justifies itself by referring to its own internal, unenforceable guidelines rather than external laws and policies to which it can be held accountable. I believe Mr. Garagosian clarified at the last meeting that this is the stage where enforceable provisions are determined, not the design review stage. With regard to lack of enforceability of the vague specific plan, a few quick examples are the developer advertises net zero water. There's nothing enforceable about this concept. Several possible ways are suggested by the developer that the city could try to implement, but there is no evidence that any of them would actually achieve anything along the lines of net zero, and the developer is not contractually responsible for making that happen. It's a completely unenforceable aspiration, and MIG several times told the developer to stop advertising it as a community benefit, because it isn't. Saying the development won't burden the community's water supply is not a benefit in any case. In addition, the advertisement of 100% electric homes is also unenforceable. There's no requirement that the homes be all electric. All or none of the home buyers might choose all electric. We just don't know. That's just one example of how the specific plan is more of an aspirational document filled with a lot of shoulds and very few shalls, which are the only things that are enforceable. So perhaps most importantly, the off-site plan, which takes public land and gives it to the developer, is completely up in the air and is obviously not enforceable at this point. We don't know whether or not the county would allow the widening of Carter or what the environmental impacts of doing that would be. The off-site project presents significant new environmental impacts that have not been subjected to the required CEQA review and must be recirculated, as attorney for the Protect Sierra Madre group, Ms. Grossman-Palmer and Mr. Bassio this evening have argued tonight and in correspondence. Please keep in mind that a decision not to recirculate an EIR must be supported by substantial evidence in the administrative record. That's the language of the CEQA statute. If you decide not to recirculate, your decision must be supported by substantial evidence in the administrative record. In closing, I would request that this commission not only vote to recirculate the EIR, but also require an independent review of the final once it has been recirculated. Right now, you're being asked to certify an EIR of a specific plan that's still a work in progress. And that was prepared by the developer's firm in conjunction with the developer without independent review of the draft that was actually circulated or the final, which includes the brand new off-site plan. When MIG was given the opportunity to review an early draft, one of their concerns was that they were being asked to review what was, in their words, a moving target. That's still the case today. The specific plan and the EIR are still moving targets because the boundaries of the project are unclear and its terms unenforceably vague. It's a recipe for being blindsided later. So I urge you to, at minimum, require more specificity in order to properly evaluate the true impacts of the specific plan and to vote for recirculation of the EIR. Thank you very much.
Thank you.
I'm one of those who put in a card to speak off the, for not on the agenda. And
Good.
I got one of these for you with them, just because I threw it together late and I'm not sure if I'm gonna be able to. It's a short one. I am learning an awful lot about building and houses and land and things that I never knew, and I'm not sure I would have particularly tried to find out. But recently I've been reading some things about construction. Oh, I'm sorry. Sure. Barbara Velturo, 380 West Carter. And I have on here that there's something that was not mentioned in the DEIR or the FEIR or the specific plan that I think probably needs to be considered, and I've just recently learned about it, so I don't have enough information to tell you, but questions anyway. I have one of the most critical concerns of the city now and in coming days is the ongoing and worsening drought and possibility the city may not be able to supply the water needs of its citizens as required in our general plan. The recent announcement from Metropolitan Water District and the November statement from the San Gabriel Valley Municipal Water District, which supplies our water, make it clear that there is no excess water to be provided. San Gabriel Valley Municipal Water District's allotment for 2022 has been reduced from the state water project to 0 for the first time. New Urban West has been in the construction business for a long time, and for a developer to be successful, he has to be able to calculate the projected costs, of course, to build a project, and to be able to convince his investors that there will be enough profit. I've recently read some articles that I didn't and I didn't realize that there is a huge amount of water used in construction and in dust mitigation. I wasn't sure exactly how much. There's nothing in the specific plan. Oh, I shouldn't say that. The mitigation does say that they'll water 3 times a day or as needed, but there is a drought. There's a lot of dust in the summertime, and they are going to dig between 5 to 18 feet of topsoil out of this whole entire property. Writing that, of course, the actual amount depends on what work there to be done, the soil, the air temperature, the wind, and probably other factors that I don't know the first thing about. I asked Jose Reynoso about the water used by the developer, and he told me that the city does have some water that they save from leaks and things that can be used so that it's not all potable water. But I spoke to a developer who was going to provide an estimate of some of the water to be used for home construction, and after he had more information, I will be able later to get a little bit more information. But he estimated, I have an idea of water use per home for compaction and dust control. It's about 42 houses times 100,000 gallons each home. But the greatest use is dust control and the roads, curbs, etc. Said the development agreement made no provision for the hundreds of thousands of gallons of water to be used in constructing the homes before anybody's living in them. It really should be, and there should be something where that number is given to the city, or just even a general estimate. But the potable water from the city cannot be used for something like this. We don't know what the drought will be next year, or the year after that, or the year after that. We have to conserve as much as we can, at least for our citizens and for our home use. And I would hope that you will check with the developer as far as what estimates he has. I'm sure since he was going to pay the city for all this potable water, I'm sure he has a pretty good idea what's in the budget, so.
Okay, thank you.
Thank you.
Good evening, Commissioners. Lynn Coleman, Carter Avenue. Thank you for allowing me to share my comments with you this evening. I was very glad to hear so many comments about your tour at the monastery. It sounded very positive and very helpful. I was, however, sorry that the general public wasn't invited to participate, and would hope that in the future I could make a suggestion that a tour be available for residents that are interested. I also appreciated your comment about needing elevation drawings so that we can get a better sense of what the homes, the streets, and the yards look like from both a side view and a frontal view. Right now, all I've seen in the specific plan are rows of rectangles, 3 of them, and I really am having a very hard time picturing how it's set up, how it's divided, and what it's going to look like. I also have some concerns about the draft EIR because it did not mention anything about the off-site improvement plan. For those members of Sierra Madre who regularly hike, picnic, and enjoy Bailey Canyon Wilderness Park, they know this is one of the most tranquil and beautiful natural areas in the foothills. Encroaching on this special place to add a 6-foot sidewalk, widen a roadway, remove 4 mature trees, impact and likely damage 10 more, and encroach on 2 others without allowing for comment in the draft EIR is unacceptable. Not only were citizens denied their right to comment, but so were public agencies, as well as Sierra Madre's own environmental groups. This really doesn't seem like an accident or an oops. Experienced developers don't make these kind of mistakes. Rather, it seems like a deliberate ploy to evade scrutiny of an indefensible aspect of this project, to impinge on a park not owned by the applicant and their developer, and destroy the trees that give it its unique identity and appearance as a wilderness park must not be permitted. Good neighbors do not promote their own park at the sacrifice and expense of others. Based on this significant omission from the DEIR and specific plan, it becomes increasingly important that adequate time be spent studying, reviewing, and questioning the many sections in the final documents that are deliberately evasive and vague. Okay. Interestingly, there's a workaround in the specific plan that allows them to build 42 homes on 17 acres by disregarding provisions in the general plan and municipal code and replacing them with their own special provisions. The workaround states the following. Whenever the specific plan contains provisions that establish regulations, including but not limited to uses, densities, intensities, height, floor area, lot area and coverage, setback, parking, open space, and landscaping requirements, which are different from or more restrictive or permissive than would be allowed pursuant to the provisions of our municipal code, the specific plan shall prevail and supersede the applicable provisions of the municipal code. Proponents of this plan feel that because the project includes a goodie bag with a park, open space, and zero water plan, we should be grateful and accepting of their plan and not raise a fuss. But let's not be distracted by the bling and sparkles of a small park and a conservation easement on the open space. But let's rather continue to raise good questions and legitimate concerns about a flawed project that does not meet the vision that the citizens of Sierra Madre worked so hard to memorialize in their general plan. Thank you for your time and your work.
Thank you. Anyone else that had a card for the community input that meant to speak on an action item?
I had a card in.
Oh, Did you speak already? Did you want to speak on this item?
Yes.
Come on up.
Are we allowed to speak on anything on the agenda?
Just the Meadows project, just what we're speaking about.
Yeah. Are we allowed to speak on anything that's on the agenda?
Just the action item that we're.
So we can speak about the Meadows project, is that correct?
Yeah, that's what we're here
Okay.
for.
Let's talk about the Meadows project. Nobody spends $2,200 and spends.
Wait.
Your name, please.
Thomas Padilla.
Thank you.
Address?
Nobody spends $5 million for 2,200 square feet. In San Dimas, there are garages that are 2,200 square feet and corrals. What people buy in Sierra Madre is Sierra Madre. They buy the fact that the Body Snatchers was down Kirstein Court. We've got everything. When people ask me to describe Sierra Madre, I say it's Mayberry RFD shoehorned into a vast conglomerate of cities. And it's been that way ever since I moved in here, which was 1981, at which point in time I could stand on my back porch and see Catalina Island. Highland, which is directly behind me, decided that they got a variance to go R2 on a piece of land right behind me, and overnight, 5 two-story condominiums shot up along with a brick wall, and that was the end of the view. You're not voting on whether or not this project is going to be improved. You're voting on whether or not this lifestyle is going to stay the same for your children and your children's children. What's to stop Alverno from saying one day, we got a $25 million property, we got to cash this puppy in? They're spitting distance from the Meadows. They're going to get their approval. Why? Because the Meadows is a precedent. It allows any developer in the future that wants to come in and develop large to point at the Meadows and say, you let the Meadows do it, why not me? That's what you're dealing with here. I appreciate, this is the first planning commission meeting I've been to. I appreciate the hell out of you guys, especially because you don't get to wave the flag of city councilman whenever you walk down the street. Why you do this free is beyond my comprehension. I have sat here since this meeting started and seen a large amount of gray hairs appear on every one of you that were not there when this meeting started. I thank you again for your time. I hope you'll look at what really matters here and not the few $1,000s in property taxes that we're going to get.
Thank you. All right. Anyone else? Okay. Well, then I'm going to again close the public meeting. And since we don't have very much time left, I'm not going to go on to deliberations, but I'm sure you guys have questions. I think what I'll probably do is want to bring that back to the applicant, because I have some. I don't know if you guys have a number of questions, or we'll save it to the next meeting, but I'd like to maybe, if something's burning on your agenda.
I've got a question.
Go ahead.
So I've got a question about the final draft being, and its circulation. Was that circulated to the public?
Yes, it was. It was posted online. The final environmental impact report included the comments and addressed the comments that were identified in the draft EIR. There were many comments regarding providing additional ingress, egress from the project site, and that's what spurred the off-site improvements.
And it looks like there are some maps in there that show that the Carter enlargement, the improvements?
Yes.
So it was in the final draft?
That's correct. That's
How long did the public have access to this and were allowed to comment on the final?
The public had 90 days to comment on the draft EIR, and we had, I believe it was 60 days for the final? Yeah. 45? I can't remember now. Yeah.
How many meetings did we have after the final was available to the public?
We had a joint study session with the city council.
Okay.
And going back to the comment period for the final EIR, there isn't an additional comment period for the final EIR.
Okay.
So that was just publication of the final.
I'm asking all these questions because I'm very confused and just a bit frustrated that I keep hearing about the draft EIR, which seems kind of irrelevant at this point. So, if anybody thinks that's wrong, please speak up.
You're entitled to. Go ahead, John, or Bob. I don't know who wants to go. If you think of something else, Peggy, go ahead. This is.
Well,
do you have anything for the?
Well, tonight we've heard a couple of issues that I think can get clarified. We have some people that are right below the proposed park that are concerned about people in the park looking in to their backyard, and I don't think that's an insurmountable problem. I think that the applicant and the homeowners can work together on what kind of barricade is in between the two that'll provide privacy. That park does not look like it's packed into the south end of the property line anyway, so I think there's plenty of room for planting and other things that'll do that. So I think that's easily done. The whole question with the water, I haven't heard anything that says it's different, but I'm sure that we can get a quick opinion from the water department as to whether anything has changed from the last time they've done it. The interesting one is that from about the conservation of the land, I kind of agree with Commissioner Hutt that if it's part of the conservancy, then they can still use it for what they want to do, except for putting buildings on it. You know, I can tell you that fire has burned all the way down to the edge of that wall and the street that separates that property from the current retreat house, and so you know, having some kind of plan for that property that addresses the fire concern issue and addresses the conservation issue, I don't think is an insurmountable issue. I think that can be. I think that all the parties can get together and decide. Well, yeah, we can use it for the purpose of the monastery, which is to allow people to, you know, walk in there and put in areas for them to, you know, meditate or whatever, and still address the fire issue and still address the conservation issue. I think all those are easily addressed. So some of the stuff that we've heard tonight, I appreciate. I'm glad to hear the facts and the concerns. Some of the stuff we've heard tonight is non-specific, that somebody's a dirty bird because something happened, and it's not really anything that this body can rectify or change, or, we don't police the police department. If somebody puts a flyer on your door at 5:30 in the morning, that's not something that the Planning Commission has any control over. So, I can't do much with that.
Go ahead.
Well, I guess we're not going to get into serious deliberations tonight, but I would like to say a few things. And then I really hope that one thing we could do tonight is decide when we are going to deliberate and what we're going to deliberate on. Because I think one commenter said earlier, we got a really full agenda of things to do. And I don't think it makes sense for us to come to each one of these meetings as if we're going to talk about everything. Because that means we don't plan appropriately. Because we need to say, okay, this next meeting we're going to talk about this subject and this subject, so that we can really focus in and be attuned to that particular part. So that's really what I'd like to get to before we leave tonight. A couple of observations. One is on the open space part. I really don't see why we'd have a problem doing that lot line adjustment. Again, it's not ceding control, it's just making sure that we have that appropriately zoned. With regard to the Sierra Madre Mountains Conservancy, I don't understand, why haven't they come and spoken to us? Because we've heard rumors and hearsay, but please, somebody from Sierra Madre Mountains Conservancy come to a meeting and talk to us. I think that would be very helpful. Let's see. If you'll indulge me, I do want to talk a little bit about the lot line thing, the number of parcels, as I did read that whole letter, and I want to talk about it before I forget the next meeting. We've heard, from I don't know how many attorneys, so I'll add my bit in. And as you can see, attorneys can differ on this, but it seems to me that there were 3 legal lots, and nobody's contesting that the lots were legally created. So then the question is whether the lots over the course of time were merged or combined. And I didn't see anything in the record that said they were merged or combined. One of the ways they can be merged is if there's a building that's built that goes across the lines, then they're functionally merged. That didn't happen because the 2 of the parcels are down in sort of the open part that we're talking about here. The fact that they were tied for assessor parcel purposes is just a tax inconvenience. It's nothing to do with the legal lots themselves. And the fact that they were added in to a deed and given together, it doesn't in and of itself merge those lots. And there was different cases cited, but the point of some of those cases where they were transferred by meets and bounds was really calling into question whether they were ever properly established at the beginning, not the fact that they'd been merged. And here again, these are, I don't think anyone's complaining that they were never properly done. So it seems to me pretty clear that there are 3 legal lots on the property, and a lot line adjustment is perfectly reasonable. And my preference would be to, cut it into 3 different lots, one for institutional, one for the project, and then one for open space.
Did you want any feedback from the applicant's representative? I know that because they did opine about this when we had our.
Well,
or does it?
I read all their
Okay.
letters, so
All right.
I don't really.
All
I mean, that's my legal opinion.
That's fine.
All lawyers are entitled to their own. I think the key is I don't think it's clear cut one way or the other that you can say everyone agrees it's this. But I think it's reasonable to interpret that there's 3 legal lots. That's the way I read it.
Do you have any questions, or are you done, John? I'm sorry.
Yeah.
Okay.
I guess some of the things that I just wanted to reiterate that we spoke about earlier that we could use clarification on. I think understanding the square footage in an apples to apples comparison. This is what the square footage was. I mentioned that there is a number in here that is the maximum square footage. Somebody came up with that number somehow. It must be based off of a design of some kind, and understanding what that design is so that we can understand how that translates to our code, which will govern as soon as the keys are handed over. I think that there was some work done on the timing of when events would occur as part of the development agreement. I'm going to reserve my comments until we get further along in the process, but I suspect that we'll want to tighten up those. One of the things that we spoke about at the last meeting that needed tightening was the timeline that was allowed until the expiration of the agreement was something like 10 years. I don't think anybody wants to buy a house that for the 9 years after you buy it, there's construction going on. And I don't think that we want the community to have to wait that long for the completion of the total project. And so I didn't hear, excuse me, any changes having been made to that part of it. So that'll be something that's on the radar eventually. One of the things that has been a challenge is definitive information. I know that it's not all final yet, but if you look at some of the information in the specific plan that has to do with one of the big challenges that the neighbors are having with this, if you look at the elevations, the elevation today at the fence line is 5 feet higher than the proposed elevation on the proposed elevation map. And so if the park is in fact going to be 5 feet lower than the level of the ground at the fence line today, which is what is indicated by this, then a lot of those concerns about being able to stare right into the neighbors aren't quite as large, and shorter retaining walls that protect the views and also allow for views to be maintained to the extent possible are something that could be considered. So I know I keep bringing this up, but being able to really understand which of these are
The truth.
what will actually be built
Right.
versus what if this is a projection, and honestly understanding what our margin of error using, if the specific plan is our rubric against which we get to judge, understanding what that margin for error is against it. So that's something that I would love city attorney to contemplate and come back to us about. And if these are much more final, then I just don't know if this is final or not. And so understanding how final those are, I think, would be helpful to us.
Peggy, any questions for the applicant, the representative, or any comments or anything you want to know?
Well, I think the water, how they're really going to make it a water
Net zero.
minimizing project needs to be better described than net zero. I mean, we need like parameters and gray water systems and, you know, a lot more than Cal Green and net zero. So that is one of the things that I would be interested in fleshing out more before approval.
Yeah. Would you like them to address it at this point, just briefly, if you would like, if you want to, Mr. Frankel, or whoever in your group?
Certainly. So at a high level, net zero water is achieved doing one of three things. Firstly, it is the potential purchase of supplemental water. Obviously, we know that no supplemental water is available at this time. The drought is a current moment in time. Long-term water projections are based on the city's urban water management plan, which is required by state law to be updated every 5 years. And that document looks at dry conditions. It looks at multiple dry years, and it forecasts how much water will be available using state and local data. And so our analysis in the EIR is based on long-term forecasting, not one particular dry year. Hopefully we have more rain next year and the situation may change. And so the purchase of supplemental water may be available in the future. That is a legally binding obligation of the development agreement, which we will fund, and the city can use those funds accordingly to buy that water, should it be available for the benefit of the general public. That does not mean that these homeowners would not pay a water bill just like anybody else. We're not prepaying their water. They would pay their water bill and have a water meter just like anybody else. But the supplemental water would be in an amount equal to the anticipated total indoor and outdoor use over the lifespan of the home, a 50-year period. So that is the first way, if that water is available. Second way, in the event that, and the development agreement contemplates this option as well, in the event that that water is not available, and we would use that water to fund a lawn retrofit program. And we've worked with our landscape architect to determine how much water per square foot a typical average lawn will use, the size of an average lawn in Sierra Madre, and if we fully funded approximately $20,000 per homeowner, what that would do to offset the water usage anticipated at the meadows. And so we calculate how many homes would we need to retrofit in order to fully offset all of the anticipated, again, indoor and outdoor demand over a 50-year period associated with the project. So that's the second way. The third way is the city could make infrastructure improvements to their existing water mains, which the city manager has opined are subject to leaks. They are old. And so avoiding leakage and water loss is another way to reduce demand and conserve water, again, in an amount equal to the water that will be used at the project. So when we say net zero, we're talking about how do we offset, the project is using 1 million gallons, for example, how do we offset that 1 million gallon use by purchasing supplemental water, retrofitting lawns, or making other infrastructure improvements in the city that will result in a commensurate level of reduction.
Okay, great. Thank you. Well, I only have one question, because the park's very important to me, and public access to this area is very important to me. And I'm just going to throw this out here because it speaks to some stuff that was said that I can't even, I don't know if it's true, so I'm going to ask either the Passionist, the representative, or who knows the answer to this question on their side. One of the claims was that a Mr. Clyde Stoff approached to pay them $25 million, which is $5 million more than New Urban West is paying for the property, to build a smaller 90-unit assisted living facility that would have a smaller footprint, and they would still not destroy the trees, et cetera, and they would still include a park. Is there any is there any factual basis to that?
Can you restate your question, please?
Someone submitted information saying that a Mr. Clyde Stauff, I don't know him, in his group. No, I want the Passionists. This is not, I don't want, this is a claim that I want somebody, I just want to know if they were ever approached by this person to know about this project. Because this is like a smoking gun to me for a park that we'll never get, or we could get in another, because the EIR speaks to an institutional development, but it's huge. And so this is making a claim that somebody offered you more money, and I'm not saying that the money's the whole issue, but part of it is because of what's the purpose of it, what it's being used for. But are you aware of that? Did anybody present that to you?
My name is Cameron Thornton. I live at 1347 Jaley Circle in Glendale, California. I am a spokesperson for Madre de la Rosa. Mr. Staub called me in March of 2020 in the height of the negotiations for the MOU. And at that time of the phone call, he was representing another developer in Orange County. And I explained to him at that point that we were in the process of completing execution of an MOU with the city of Sierra Madre and with New Urban West, our development partner, and that we had identified that single-family residential use was the best use for the property. At no time did Mr. Staub ever present a contract or a specific offer. It was all verbal. That information then became public through a posting through Facebook in the city of Sierra Madre. And I don't remember the woman's name that posted it, but she had been contacted by Mr. Staub, to the best of my knowledge, and as well as the developer. There was never any conversation about money. And it was all after the point of our negotiations with the city and with New Urban West. And that's what they were told.
Okay, so you didn't go any further with it because you've already entered into an agreement, and there was no
That is correct.
And the details that are here were not.
The details that, I don't know what it is you're reading,
That's,
and I'd be more than happy to read what it is and to
Sure.
respond to it.
okay,
And I don't have my specific notes,
okay,
but that's as I recall.
okay, that's fine. That's enough for me. I thank you. I had to throw that out there because these are the things, that's like you said before, this is not a court of law, but it bothers me because I'm interested in the park. That's a very important part of the development for me personally, and public access to the area. I think that's all I'm going to say. I think, John, since you have an idea of how you think the procedure should go, why don't you?
I think it's most important that we just decide what's the next thing we're gonna tackle, so when we come to the meeting, we've read the right stuff, right?
Sure.
Because there's plenty to read, and I don't think we can commit all of it to memory. So if we wanna, look at the EIR first, that's fine, if that's really what people wanna do. My preference would be to sort of get a general gist of the general plan amendment, or maybe we could, well, it's pretty late now, I don't know if we could talk about that now, but,
You can put that first. No, the general plan, I liked your suggestion. I don't know how everybody else feels, but maybe,
I think we're gonna have the most stumbling over the specific plan. I think that we need to fill in what that really means in terms of all the square footage and the sizes and things like that. I think the EIR has been debated back and forth, and we've heard enough about that. I don't have a lot of angst over the EIR, but I would like to make sure that the elements that are presented in the specific plan are made public, so that we know what we're buying, kind of thing. Because the size of the lots and the size of the buildings are going to make this look a little different than the rest of the town. And I like the idea that we try to compare them, if it were an R1, what would it look like? What would we do?
all right, so maybe the specific plan first versus, and then the ER, or,
Well,
go ahead, I'm fine, Tom, go ahead.
Yeah, I think it might take some time to make sure that they get all the right calculations, the right way to display it. And so if we want to have the next session be something other than that, so that that can be worked on in the background,
That's fine. I'm okay with that.
I don't know, I agree that the specific plan, from what I've heard, is where we're gonna spend a lot of our time.
Mm-hmm.
I think you bring up a valid point that if we can't get past some of the other findings, it doesn't matter. And so maybe we start with the other findings, and that gives everybody time to work on the specific plan. Does that work, or you?
Yeah, I'm good with that. I think I guess one thing we could do is we could discuss the sort of the general plan concept. I think the lot line and the zoning sort of the sort of bigger concept of the development first, and then perhaps do a little bit more of a fulsome explanation of our concerns and issues with the specific plan, so that people can be working. I guess I want to say that when I looked at the specific plan and I listed concerns, I don't want an explanation of why my concerns don't matter and I shouldn't worry about them. I want a change to the specific plan, because it's not. I couldn't support the specific plan as it's written now. So I just want to make sure we're all working towards getting something that we can vote on and approve, and not just sort of like more sort of window dressing of, oh, it sort of does that, and then there's this fluff and shell game. Because if we do that, we're going to spend a lot of time where I'm going to vote recommending against approval. But I think we can get this specific plan there.
Mhm.
I just want to make sure that people are willing to do that. I guess this is what I'm saying.
That sounds reasonable. We can do that first. I just thought you wanted to do something with the general plan amendments first, so we could get to that, but I think.
Well, I
we
mean,
should-
I guess the fundamental question on the general plan amendment is, and I think I said this quite a few meetings ago, to me, whether it's an institutional use or a residential use, it's really more about the intensity of the use. And so if the applicant wants to use the lower half of this property as a residential use, I'm fine with that.
Okay.
Right? And I mean, to a certain extent, that's all I have to say about the general plan amendment. It's right there. And if there's a consensus on this commission that agrees with that, then we can sort of get into the specific plan. But if y'all think, hell no, institutional use is the only thing that makes sense, then
No. Okay. No, I think that makes it clear to me. Then we should agendize or start with the specific plan.
I don't think that will be a showstopper in terms of, I think we can work through that. We're pretty good at looking at both sides, institutional or R1. Yeah, that we can do that.
Yeah. But you bring up a good point that if we don't give specific feedback as to the changes that we're looking for in the specific plan, we won't get them.
Yeah.
That's fine. That's all I
and
saw.
they have to, and they're gonna have to digest it and come back with their solutions. And for some of what I'm thinking about, I would like a little more examples. And in other words, we're seeing a lot of flat paper. We learned a lot when we walked the site. One of the things I thought when I was walking around is, hey, story pools might be really interesting. So, but anyway, in other words, something that would give us, what does this look like from this side, this side? We're hearing a lot from neighbors, oh, it's going to block my view. That the park sets up a big buffer between the existing homes and the new ones. I mean, they're going to be a long way away. That's one of the things I learned on the walkthrough. They're not proximal at all. So, okay, I understand people who already have houses that are up against the lot lines, and what are they going to see and what are they not going to see? For that we have to write rules. Where will the two-story houses be or one-story houses? How will they mix up and things like that? But I don't think that's insurmountable. But having the applicant give us some solutions first, that might be helpful.
Chair President, if I could.
Sure.
Thank you. So certainly we're happy to evaluate any potential modifications to this specific plan. What I would request, though, respectfully, is that we get in writing a list of specific changes that the commission would like to see prior to the next meeting. And I think that's really going to help us evaluate. I think that we completely understand and hear the concern. Perhaps the homes are larger than would otherwise be allowed. I think with that issue, the table that was shown, the difficulty with that issue, I think seems to be the one that everybody's struggling with perhaps the most, is that the city's code has a cap, a hard cap. It's a certain percentage of lot area above the minimum. So it's 22 or so plus a certain percentage above. And so that chart you saw, under the city's R1 zone, it would be capped on those smaller lots at about 2255. And so that's a hard cap. And so saying we want an apples to apples comparison, that's not what we're proposing. So there will be no comparison to the specific plan other than you can see the delta between that cap and the potential maximum in the specific plan. So in some cases, it may be double. In some cases, it may be less, depending on the size of the lot. So that's a policy decision for you to make. And what number, whatever that is, if you say, well, it's 3,000 or 3,500 or some other number, we can evaluate that, but I need to know what that is. And so talking about just in generality, it's too big or we have discomfort, I understand that and appreciate that. But in order to really give you some certainty, I really need to know what the expectation is. And so we'd really appreciate the opportunity to evaluate these concerns. And so if you want us to evaluate a larger setback or different lot coverage or whatever that is, if you could just give me a list of those things in writing, and hopefully you'll have the time that you would need so that we can evaluate them, and that list can be comprehensive so we can then go ahead and evaluate it. I think the concern that I have seeing this is that we've had 2 meetings And I've heard a lot of feedback, and it's been very helpful. The site visit, I think, was helpful, but we do need to get into the specifics to be able to understand how we would in fact change the specific plan instead of kind of staying at the 50,000 foot level.
Yeah, I think one thing just to comment is, we can't give you a written list before next meeting because we can only deliberate at the meeting. So we can't, the problem is we can't get together and make a list, because we're a Brown Act body. So I think if we want to sit at the meeting and go through that chart and bang out each thing, I'm totally good with that.
Yeah.
I totally agree. We want to get into the weeds as much as you do. We've had a lot of these meetings, and we really do want to get into the weeds and the details and help. And I think, just for clarification, the apples to apples concern, this commission has approved almost every house that's come before us that asked for a variance to go above that square footage. So we're not saying that we don't want to allow houses that exceed that square footage. What we're saying is the calculation that you use is different than the calculation that we use. So we can't that's the apples to apples comparison that we're looking for clarification on. It's not the hard cap. So I want to make sure that you understand the difference.
Completely understood. And I think with the table that was presented, that does reflect what the maximum for each lot would be under the R1 standard. So I know that was done more recently, but if you look at that in that column, that will show you on a lot by lot basis. On lot 1, the maximum in R1 would be 3,600. On lot 2, it's going to be 2,600. And then you can see on every lot, based on your calculation existing R1, what the maximum would be.
And that's not what we're looking for clarification on. What we're looking for clarification on is the floor area coverage that you have calculated in the specific plan isn't the way that we calculate in the R1. So we can't, you can say a number, it's calculated completely different than the way that we would give a variance today. And so we can't do an apples to apples comparison. We're fine with going over the maximums that are in the R1. We don't understand the number that you're saying and how it relates to ours. Footnotes don't help us to calculate out a chart that says.
If I could say this in another way, I want the definition of floor area in the specific plan to be the same definition of floor area in R1.
Because your 3,000 foot house and what we think is a 3,000 foot house is not the same house. They're very different.
And then if you say our definition in the R1 penalizes porches and balconies and useful architectural features, I agree with you. And so if you want to say, and I want an extra, 500 square feet for porches, balconies, and these, fine. That's fine, because then we can look at that. But I want to have a definition that says, our R1 is X and yours is Y, and we can look at them directly across.
Understood.
Yeah. Thank you.
Great, thank you. Yeah, we apologize. We've gone over the public comment, so I'm sorry that you haven't had a chance to help us sort of flesh out these details. And sometimes we'd have a meeting where we would do all just that, and just like we do with all our other, we make suggestions, they say they'll make some changes, and they come back at the next meeting. We haven't really had that chance yet. So now that I've closed the public comment, we can start with that in the next meeting. So appreciate your patience with that. So again, do we have a consensus? We'll start with the specific plan.
Yeah, we're gonna hit the general plan. That's gonna take just a few minutes. Then we're gonna start digging in the specific.
Okay.
Yep, I'm good with that.
Very good.
Yep.
Excellent. All right.
Progress.
Yes. Thank you. All right. So.
And the staff's presentation was very, very helpful.
Yeah, thank you very much.
Very helpful.
That ticked off a bunch of issues.
That one I'm going to print up completely. It's like I got pieces of all the other ones. So, all right, very good. Thank you. We're not done yet, so if you're going to leave, please do so quietly. We are at reports. Go ahead. Planning commissioners, any reports? Peggy, anything? Tom? Something going on? No?
Nope.
Really? Maureen? Bob?
That's what I was just going to say. On
Go ahead.
on the Meadows
We
project,
have
I was
to
waiting
make a
for a motion.
Oh, I'm sorry.
of Continuance to a date certain.
Yes.
The next meeting that was identified, we were looking at the first meeting of each month is June 2nd.
Okay. So I have a motion.
I move we continue to a date certain of June 2nd with a focus on the general plan update and detailed working session on the specific plan.
I second that.
And seconded. Those in favor?
Aye.
Aye. Those opposed? All right, passes unanimously. Thank you. Sorry about that, Director Gonzalez.
Next item on the agenda is Planning Commission reports, if you have any reports.
Yeah.
No reports. So staff reports, our next Planning Commission meeting is on the 19th of May. And we do have a public hearing for a variance. So we will have that project, yes.
Oh, boy.
I also wanted to inform you that we've had discussions regarding arborist report, that we should have the Public Works Department should create an arborist report. They have done that, and it's in use now.
Great.
So they can pull from a list of arborists that they selected.
Excellent.
Okay.
Yay, thank you very much.
That concludes the staff report.
Okay, very good, thank you.
I'm sorry, I did have a question. When or are we going to have the filming commission, the Community Services Commission, come back before us?
Does that come back to us?
It doesn't come back to us because that's not under our purview. We provided comment, and it's going back to the Community Services Commission
Excellent.
for
Good for them.
consideration and then to City
Do
Council.
we know when their meeting that's gonna consider that is?
Most,
Didn't they meet today?
It should be, they met today, but that was not on the agenda. It's gonna be either, they meet once monthly, so I'm anticipating in June. And we're pairing up the filming ordinance with the temporary use permit ordinance as well, that the Planning Commission has already made a recommendation to City Council. We want to take both of those items together, yes.
Yes, go ahead.
I'm not sure I heard the question, but did someone ask when the Community Services Commission was going to consider this item?
Yes.
They're going to consider this item on May 16th.
Okay.
The filming permit ordinance, and your proposed amendments, Planning Commission.
Okay.
And from there, it goes to City Council for adoption.
Yes.
Good. Best of luck. All right.
And was there going to be a ministerial extension of the annual
TUP for
TUP
Alverno?
Alverno for an interim period until City Council has made decisions on the filming?
Right now, they're already on a annual TUP that was submitted, they submit by calendar year
No, it expires July.
in July, okay.
They go August to August.
Right. Now, I have had communication with Alverno regarding the conditional use permit. They did pick up the application, and I'm waiting for a submittal.
Okay.
Excellent. All right.
We should schedule that on the same day as this, so.
There won't be anyone else in town.
Yeah. Right.
I'm busy that day.
All right.
Whatever day it is.
Okay. So then we will adjourn the Planning Commission to our next meeting on May 19th. I never get to use that. Shows how orderly and peaceful our meetings are. Wonderful.
Thank you, Commissioners. Have a good night.
Thank you. Thank you all.